All right, good afternoon. I know there are a lot of people here, and I'm assuming that it's going to be for one bill over the other three. So before we start, I'll just tell you the order that I'm going to go in. I'm going to hear Senator Albert's SB 27 first, and then Chairman Leverett's HB 997, and then Representative Earhart's House Bill 1076, and then SB 74, Senator Burns last. So if you are here at least for the first three and are here to testify, if we can make sure that you are in the room, if you can make some room for those people, and then when we have the SB 74, anybody that wants to speak can come back in. Just want to make sure that everybody is here for their bill and can speak for the bills. I think there's more than one sign-up sheet. Oh, those are, okay. Okay. All right, so first bill is SB 27, Senator Albers.
Thank you so much, Madam Chair. If it would be okay with you, I would ask Ryan with the Anti-Defamation League to join me, if that's okay.
Of course.
Come on up, Ryan. Madam Chair and committee members, thank you again for hearing this bill that worked its way through the process last year and unfortunately just didn't make it in the last hours onto the floor. I want to do a recap of what the bill is, and then we'll just do some section-by-section updates. This committee actually helped perfect this bill last year and made some good little tweaks and changes, so thank you in advance for that help. And I want to let you know we're working hard in the Senate for my fellow members here over in the House, and we've already passed 3 House bills out of my Public Safety Committee just this week alone. So this is Senate Bill 27. And this is the Georgia Anti-Doxing Act. You may remember last year I was here with our former Attorney General, Sam Olens, as well, who has helped this bill along the way. But doxing is a contemporary form of harassment. You've all probably seen this now on the news, and unfortunately, often in an ugly light. It is a gross violation of people's privacy, results in both emotional distress, reputational damage, and in cases, physical harm to people. It's increasing as our lives become more digital, and we need to address this issue very urgently. This bill provides a comprehensive approach to combat doxing, and not only criminalize the act, but it also has protection for the victims, which we want to be clear that the victims are the ones we're here to support in Georgia, but we also protect free speech. This legislation recognizes that the punishment should fit the crime, and the penalties are enough to deter people, because the goal is we don't want them to do it to begin with. There are clear definitions of what constitutes doxing, and I'll take you through the bill in certain areas to make sure we have crafted this and thread the needle appropriately. So with that, there are several sections to the bill. The first part of the bill, under Section 2, defines what doxing is.
And Chairman, not
yes,
to interrupt, can
please.
You just confirm the LC just
yes.
to make sure?
Absolutely. You should have in front of you LC 481609S. Yes, thank you so much. Section 2 defines doxing and then qualifies what's called the offense of doxing, which states that a person committing doxing they transmit communication through the internet to frighten and harass people of where they are and what they're doing. Sharing someone's location could obviously cause them great harm and stress. And if you think about, unfortunately, today's bad actors are out there. And they're going after folks for domestic abuse and violence sometimes. It's going after, unfortunately, sadly, anti-Semitism. We've seen it everything from celebrities to elected officials to business leaders to everyone in between, and it's people in our very districts. Also talks about how a victim can petition for a protected order against people that are doxing. And it puts in there the crimes, which would take it to a misdemeanor of the high and aggravated nature. And the second one would take that to a felony. It is also that civil action can be enacted so people can seek damages should they be doxed. The bill is fairly large for what it is, as far as the number of pages. In 5 of legalese, a lot of a new language, but it is very carefully constructed. Again, with all parties and the both your committee and the full Judiciary Committee helped perfect this last year. With that, I'd open it up for any questions.
All right, members, any questions? All right, Representative Penich.
When it's time for a motion, I have one.
Sure. Anyone else? All right. I think we have actually one person signed up to speak. Do you want to say anything? Add anything?
I just
before?
appreciate you all.
Sure.
Hey everyone, my name's Ryan Pelfrey. I'm the Senior Associate Regional Director with ADL Southeast. We cover Alabama, Georgia, South Carolina, and Tennessee. Thankfully, the Senator kind of covered everything for me, so I just wanted to say thank you all very much. I know a lot of this work was done last year when myself and my colleague were here, so just thank you again, truly.
Sure. Thank you. All right. I have one person signed up to speak on this, and it's Blake Feldman. Is he in the room? Blake? Okay. Sure. Come on on. Yeah. If you can say your name and the organization you're with first. Thank you.
Sure. I'm Blake Feldman, and I'm Senior Policy Counsel at the Southern Center for Human Rights. And to us, we're still concerned with the constitutionality because of overbreadth concerns, particularly with misdemeanor doxing. With the intent element, but also just the definition of personally identifiable information, including employer and future location. Recall before the full Judiciary and Non-Civil Committee last year, there was a good example mentioned by someone who testified, which was under the plain language of SB 27, posting a negative Yelp review, which identifies a specific waiter, the restaurant where they work, and that you had a negative experience with them, could satisfy the elements. And to us, we think that that still applies, even though this is a much better version of the bill, and it has been limited, but we still think that that is true. And just when it comes to overbreadth, specifically, that there's an extreme constitutional remedy for overbreadth, which is if it's too inclusive of protective speech, it doesn't matter if there really is a bad actor who is intending to cause harm. The entire statute is not enforceable, which is an extreme remedy, but it's extreme because of how detrimental to democracy it is to deter and chill protected speech. The only thing that I would add to that example, though, is because there's so many, I don't want to come up with a bunch of hypotheticals, but the Supreme Court of the United States has spoken of the ability to criticize government and government officers as the central meaning of the First Amendment. But criticizing an elected official could, in the same way from that example, could result in prosecution under the plain language of the statute. And also, it does not distinguish between posting the personal identifying information of public and non-public figures, but also speech concerning public issues, not just whether you got bad service at Waffle House. But speech concerning public issues is afforded heightened protections. So the Supreme Court has said expression on public issues has always rested on the highest rung of the hierarchy of First Amendment values. Speech concerning public affairs is more than self-expression. It is the essence of self-government. There's a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. So for these reasons, we think that we would prefer doxing be handled through civil liability exclusively, but to the extent that this bill could be improved to address some of the overbreadth concerns, that we consider constitutional infirmities of the bill would be to narrow personal identifying information a little bit more. And also, we don't believe, last year was discussed a lot that the Counterman decision established that this intent would be fine. We think that Counterman that concerned a case regarding true threats. In Counterman, a Colorado man was criminally prosecuted for repeatedly messaging and harassing a local artist. And some of the messages included threats to her life. The court noted that true threats are serious expressions conveying that a speaker means to commit an act of unlawful violence. The question before the court in Counterman was whether the First Amendment still requires proof that the defendant had subjective understanding or reckless disregard was enough. The holding in Counterman was narrow and essentially states that to prosecute an individual who uses true threats, an unprotected class of speech, the prosecution must prove at least a mental state of recklessness. We don't think that that should mean that reckless disregard, especially once or twice or 3 times removed, as it is in SB 27, that would clear constitutional hurdles.
Okay. Any questions? Representative Panish.
Hi, Mr. Feldman. You and I know each other. Did you present any type of amendment, or how would you more narrowly define personally identifiable information? Because I think it looks pretty narrow. So what are you considering?
I mean, we do prefer anti-doxing statutes because there have been many, because this is a serious problem. We prefer ones that do not allow this scheme of someone posting a picture of someone and their employer, or I see this person every Wednesday at church, a future location, that being able to use in conjunction with other information to identify a person. So I think this scheme that allows posting any of these enumerated things, including employer and likely future location, that wouldn't be enough to allow somebody to cause them harm or put them in fear of harm. So we prefer schemes that do not have this mosaic element of you can take one from your post and that's enough, even though that isn't enough information. They have to get the information elsewhere. Also, schemes that do differentiate between publicly available and not publicly available information. So it is very different to posting someone's social security number and posting that you see them every Wednesday night at church, But a scheme that we love is Illinois'. I think that's a good scheme, and it's civil liability, but it does have a lot of the, there should be, for there to be liability, there needs to be that actual consequence instead of just reasonable fear of it, and the intent. So honestly, other than those issues with personally identifiable information, which we necessarily plays a role in how we feel about aggravated doxing and regular doxing, we don't think that there's anything wrong with the intent aspect of aggravated doxing. It's just that reckless disregard for criminal liability for misdemeanor doxing that really concerns us.
All right, thank you. Any other questions from members? Don't have any. Thank you, Mr. Feldman.
Thank you.
And Chairman, I'll give you just a quick 2 minutes if you want to close it up for us.
Thank you so much, Chairman Hong. I appreciate everybody's testimony. However, we went through these same examples last year. It has nothing to do with a Yelp review, unless on that Yelp review you posted everything and said this person's horrible and they work next Thursday and you should go attack them. That's not putting I got bad service at a restaurant, and that's why they have the offense of doxing, which is built in starting on line 42 of the bill. And the Counterman versus Colorado is the exact case law that allows this to happen. So I appreciate the input, but I don't think it actually applies. If anything, it works in favor of the bill. I would love your favorable consideration so we can protect our fellow Georgians.
All right, thank you, Chairman. All right, I'll entertain any motions from the committee. Representative Penish.
Motion to pass.
All right, we've got a motion to pass. Do we have a second? We've got a second. Any discussion? All right, all those in favor of passing SB 27 say aye. All right, those opposed say nay. All right, it passes. Thank you, Chairman. All right, next bill is HB 997, Chairman Leverett. Sure, that's fine. What number are you?
Lucky 13, man.
Okay.
All right. I believe there are a number of witnesses here. I want them to sort of have
If
a
you
chance
can
to.
please make sure that the witnesses for HB 997 can be in the room and
You sit down there. Sit down there at the front. Y'all come on in. So, Madam Chairman, members of the subcommittee, House Bill 997 is a bill that, and the LC number, Madam Chairman, is LC 630038. So this is the bill as filed. So this is a bill that is trying to address various issues that we believe have contributed to, I would say, higher than desirable populations in county jails and county correctional institutions over the last several years. And in fact, I think you'll hear some testimony today that it is reaching virtually crisis proportions. This overcrowding, for lack of a better word, is caused not necessarily by the inmates that are supposed to be in those county institutions according to current state policy, but by individuals that are supposed to be elsewhere. They're supposed to be in a state facility, but they are in a county facility for various reasons. The current policy of the state, as I understand it, and it's implied in code, is that county jails are for people who are awaiting trial. Once they are convicted, they're supposed to be moved on out. If they're felonies, they're supposed to be moved on out of the county jail to a state facility, and the commissioner determines where that facility is. If it's a misdemeanor charge they're convicted of, they generally stay in the county facility. But once they are convicted of a felony, or once they've been put on felony probation and revoked, we believe the policy is, and we contend the policy is, they are supposed to be in a state facility, but that's not always happening. So the bill seeks to do a few things. First, we try to more explicitly state the policy of the state with respect to where inmates should be based on what their sort of status is with respect to the disposition of any charges. Two, we're trying to increase the rate of reimbursement to counties so that county taxpayers aren't shouldered with the burdens of housing what is basically a state responsibility. And then to clarify the period for which reimbursement is owed and the circumstances in which that reimbursement is owed, prohibit one cause of these state inmates staying in our facilities, and that's in Section 1, and then also trying to address the responsibility for cost of transport and responsibility for transport. So you're going to hear from some of our witnesses some of the, I think, more compelling real-world circumstances that have led to the bill, but what I wanted to do, Madam Chairman, is just kind of, as we usually try to in this subcommittee, is just walk through the bill and kind of explain what each section is briefly. And then I'd be glad to take questions about language, and then I think we've got a few witnesses that would like to testify. And I've suggested, Madam Chairman, this be hearing only today. I think this is it's a complicated issue. There are a lot of factors at play here. I've also requested a fiscal note, which I've requested that the chairman request one, and we don't have that yet. And I think that's information members of the subcommittee need. But I did want to at least have a hearing today so these ladies and gentlemen could testify and give the subcommittee some information I think you'll need. So,
okay.
As far as the bill, Section 1, this is the title that has to do with Department of Community Services or felony probation. And there is a system that was adopted, I think, about 10 years ago, maybe during some of the criminal justice reforms, where probation officers are giving a little more authority to impose sanction for violations of probation conditions. And apparently what, at least you're going to hear from a witness today, is happening to some extent is the officers will submit to the person who's incarcerated because of a probation violation a waiver that includes certain terms of serving some incarceration time to sort of clear the charge, but included in that waiver is a stipulation as to the facility in which they will stay, and it's a county facility. And we contend that's not proper and should not be done. We understand from the commissioner of the department that that's not supposed to be done. We believe it is happening. And so we've put some language, and that's in section 1 on lines 33 through 37, to try to make it clear that that's not supposed to happen unless you have the consent of the sheriff or the person in charge of the county facility, which is usually going to involve getting some reimbursement, but that we don't spell that out, but we just say it has to be done with the consent of the sheriff. Section 2, we're trying to address to clarify expressly the transport obligation. And then also there's a cross-reference to 42-5-51, which is the statute that sets forth the rate, and we're also adding to that statute some specifications about when the reimbursement is owed, for what period of time. In section 3, that's where we increase the statutory rate. It's currently $7.50 a day, which is something, but it's not much. I think the state acknowledges it's about $80 a day. And to be fair, the statute does say $7.50 per day per inmate and in such amount as may be appropriated for this purpose by the General Assembly. And we have appropriated additional money. So we understand the rate is currently close to $25, but so we're basically proposing to double that, which is still far short of the actual cost of housing a state inmate, but it would be a lot better. And then we added there's a cross-reference back to the previous statute, which is where the clerk notifies the Department of Corrections about the conviction. And then we are adding on page 6, that's lines 124 through, I think it goes on to the next page too, some specific sort of periods of time for which the reimbursement is owed, because the old statute basically gave the state 15 free days, and we don't think that's really appropriate anymore. Most of the information is now transmitted electronically, and regardless of whether it's the state is notified, the counties are still at that point housing a state inmate, so we believe we're entitled to a reimbursement. And then we also have a provision in that section, bottom of page 7, lines 171 through 176, which kind of mirrors the section earlier about saying that generally state inmates don't stay in a county jail unless the sheriff consents to it. Then section 4, and I think, is it section 5 too? No, just section 4 is where we're trying to make sort of analogous changes to the statute that deals with the responsibility of the Board of Pardons and Paroles for parolees who have been revoked and are currently in county facilities. So we're trying to make and that admittedly is not as big a cause of the problems we are having as parole violators. That's a fairly small number, but just statutorily I felt like the two departments should be treated similarly, so we're trying to make corresponding changes in that statute so that it would match the statutes we're changing in the corrections chapter. And then so that's basically the bill, Madam Chair, and we feel like this is a conversation that needs to be had. It would involve, I think, an additional commitment of state resources, but we want to try to engage in that conversation and try to find some happy medium if we can, because right now we feel like too much of this burden is being shifted and placed on sheriffs and county budgets when it really should be a state responsibility. Thank you. And I'm glad to answer any questions about the bill.
Of course. Thank you, Chairman. Any questions from members? All right. We have set HB, it's 997. Director Norris, you had put 399. Are you here for this one?
I am.
Okay.
Unfortunately, I had the county commissioner sign up for me.
Oh, okay. Okay. All right. Let's make
Not
sure-
to shift blame elsewhere, but
Okay.
you'll just look at the offending party and whistle.
Okay, got you. All right, Director Norris, I'll let you go first.
Yes, ma'am. Thank
Okay.
you, and for hearing the bill. Thanks to the members of the committee, and especially to our friend Chairman Leverett for bringing this up. Most of you know me. I've been around a long time, much longer than most everybody in the Capitol. And in the early years of my tenure, early 80s through the 90s, there was always a concern by the sheriffs and the county governing authorities about state inmates housed in county jails. The numbers were increasing. We went through a prison building campaign during those years, which helped. So we've always talked about inmates in county jails who have already been sentenced to prison yet have not been transferred to the custody of the prison system. So this is kind of an extension of that conversation. A lot of what the sheriffs are dealing with and county governing authorities and our citizens are paying for is the result of unintended consequences of criminal justice reform. During those years, we spent a lot of time here talking about ways to change our laws to allow people second chances. As a result, there have been a lot of second chances, third chances, and even fourth chances. So what we're seeing in the state is a growing state probation population in general. And I don't know if someone from the Department of Community Supervision is here. I'm sure they'll talk about that. They know those numbers. So it is unquestionable that some people cannot survive on probation. I, for one, probably couldn't. And as a result, these folks, they violate their probation or parole, as you said. And let me make a footnote here. We're only talking about felony offenders. The state of Georgia has nothing to do with misdemeanor offenders. So this is only felony offenders who have been given probation and who have violated their probation either by committing a new offense or violating the conditions of their probation. So in the case of the probationers, during CJ reform, the General Assembly, as Representative Leverett said, authorized community supervision officers to use administrative sanctions. Some of those sanctions had to do with the probation detention centers or the treatment centers and then home ankle monitors, et cetera, and some other sanctions. What we're seeing is a lot of those sanctions that are authorized for the officer have kept people, or let me back up, have allowed county jails to be used kind of as a deterrent. Let's put you in jail, see if you can manage, get you other services. So that's been one problem. There has never been any reimbursement to the counties for probation violators that were not yet revoked. So if they were in there on these sanctions, for instance, they were sitting there, the county pays for and the sheriff arranges any kind of services that that person needs. And I need not tell y'all and remind y'all about the problem we've got in mental illness. So a lot of these folks need mental health care, which is also the cost to the counties. So that's the one part of probation violation that has caused problems. The sheriff will tell you in a little bit in a minute, and sheriffs all over the state are telling me that their jail populations, the percentage of those populations are increasing with probation violators. So these are people that many don't go to prison, are not going to be revoked. Some are. So that's one problem. In the case of, as Representative Leverett said, jails were designed to keep people until they were sentenced to go to prison. That has changed all over the country. That's nothing new. So in that case, $750 is I think the per diem cost that's in the statute, and it has been increased through the appropriation. You know, we think, and Sheriff Powers will probably tell you this in a minute, we think the cost of the average jail is $80 or more a day. And certainly the 25 or, what is it, 25 or 40
What's that?
on the reimbursement.
24.
$24 a day is what the General Assembly has allowed corrections to provide. So that number is far short of what it costs us as local taxpayers to keep that person. So in general, that's the problem. We don't think for a minute that we have the solution. This is moving us to a solution, or a better solution, to offset these costs. Jails are not a place for long-term confinement. Many jails don't have services that the Department of Corrections may offer in the prison system. Some do. But we're just looking, honestly, Chair Lady, we're looking for some relief for the county governing authorities and the sheriffs. And we appreciate this conversation today, because this is the first time publicly we've been able to say this in years. And it's an important conversation, no matter what the outcome of this legislation is. We just kind of looking for a morsel, to be honest with you.
All right, thank you, Director. Chairman Leverett?
One question, Terry. Would you say it could easily be summed, your position is now somewhat like the position of, I think it was Marcel, shoot up in here amongst us, one of us got to have some relief?
Marcel Ledbetter.
Yeah.
Yes, sir.
All right, any other questions for Director Norris from members? All right, thank you. And Sheriff Powers?
That's correct.
Sure, go ahead.
As y'all can tell, I probably hadn't been doing this quite as long as him. I've got more hair on my head than he does, but had to take that one. I actually got into public safety in 1996 as a firefighter EMT, and then 98 I went to work at the sheriff's office. I worked in every capacity that you could possibly work in within a sheriff's office. Thought I knew the workings of the sheriff's office until I sat in this seat, which was a year ago. I was elected, and this is my first term. What brought my attention to this is every Monday I get a jail report, and I began to look at the same inmate names over and over and over and over again that was sitting there accumulating day after day after day after time, and we weren't getting any relief in our jail whatsoever from them. I did a count last Monday, and we had, I think, 23 or 24 of our inmates, 81 capacity jail, which is pretty much the average size jail here across the state of Georgia. And 24 of our 44 inmates were there on some type of probation violation charge. Some had a bond. Most of them had a bond and could get out if it were not for that probation violation. So they're being held there, accumulating time. Some did not have a bond, and then I've got a couple that's under sentence there in the jail as well. And I think my total time was about 2,717 days accumulated amongst those inmates, which added up to about 7.3 years of time that these individuals have served in our jail. With that being said, there's no relief whatsoever. Now, Terry talked about the amount of money that it costs us to house these inmates. The state, I think, is going to tell you probably about $83 a day. And we're getting a relief of, if they've been sentenced and they're beyond that 15-day window or 14-day window, they begin to give us $24 a day for it. What hasn't been addressed is what happens when one of these people gets sick. God forbid they have a heart attack and I've got a $200,000 bill. So if you can imagine a jail my size winds up with a $200 bill at the doctor's office for an inmate that's really not mine, it belongs to someone else, what it would do to our budget and our community, it would be devastating to us. And you're going to hear some numbers that it could possibly be $50,000 is what it would cost if we went to this $50 a day for last year, and maybe $60,000 in the future, but they're basing that off of 60 million, I'm sorry, 50 million and 60 million. Yeah, we could get that through real quick. Yeah.
We could probably get the bill.
Yeah, we can get it through if it was 50,000. Yeah, but 50 million, my bad, 50 million, and then 60 million in the future. So that's them basing that off of that $50 a day, not the reality of what they're going to tell you. It costs $83 a day to house these people. So that $50 million is what I helped pay. That $50 million is what y'all help pay through your local taxes to your jail. The $60 million that you're going to have to pay is going to be paid through your local people. through your pocket, through the local taxpayers. And so this is the thing this is what we're looking for relief on. And I just would, the last thing I'd like to say is I would just challenge you to, don't listen to what I got to say. Call your sheriff. Call your sheriff of your county and just ask him, because he's going to answer the phone when you call him, and ask him, is this really happening? And you're going to find out that this is what's going on.
And Sheriff Powers, what county are you?
I'm with Wilkes County, I'm sorry.
Okay, yeah, okay. All right, we've got Chairman Crow with a question.
Yeah, thank you. The numbers do get bigger up here. It takes a while to get used
They
to.
do.
So,
Yeah, they do.
and glad to see you here. Congratulations
Thank you.
again, publicly, officially. So,
Thank you.
Daryl and I worked together at Butts County years ago at the sheriff's office and known each other a long, long time. So, very happy to see him in this role. And he called me and talked to me about this. And I would call my sheriff, but he knows that what I know is hard to get that fellow on the phone sometimes. So, he does a good job, though. Just kidding. Seriously, though, what you mentioned the $24 a day if they've been sentenced and they've been there more than 15 days.
Correct.
Are any of these, what about the DCS holds for probation or anything like that? Y'all don't get anything
Don't get
for
any
those?
money. No money.
Not a dollar?
No.
Okay, thanks.
All right, any other questions from members? All right, thank you, Sheriff.
Thank you.
Next is Todd Edwards.
We're dismissed.
You're welcome to stay. We are
And Vivian Ernstess?
Vivian's just fine.
Okay,
Everybody's
alright.
got trouble with the Ernst.
Okay. All right.
Thank you very much, Madam Chair, members of the committee. I'm Todd Edwards with the Association of County Commissioners of Georgia, and Vivian and I are here to urge your strong support for it was House Bill 997, I believe. Sorry about that earlier. It's something I think throughout the years, I've been with ACCG for about 20 years, and year after year we do our policy development process, set our priorities, our agenda for the session, and rarely does a year go by where increasing the per diem reimbursement for state inmates in county jails not make that list. So we're very proud. Representative Leverett has sponsored this legislation. Again, we support it, and I'll turn it over to Vivian. She's done a great job. It was complicated, somewhat complicated to understand. If I may forward this. It's somewhat of a summary that we put together, if that helps y'all. Now, I know this is Judiciary, that's the smartest committee up here at the Capitol. Judy, the sub. So if that helps, so be it. And Vivian, I'll turn it over to you.
Good afternoon. My name is Vivian Ernstus. I'm Deputy General Counsel for ACCG. As Todd said, we strongly support this bill. It fairly allocates the burdens and the costs between counties and the state. It also very precisely defines when reimbursement starts and ends. That's very helpful for counties to know when they're going to be reimbursed and when they're not going to be reimbursed. It also prevents and reduces perhaps, the disagreement between the state and the counties about reimbursements. With that, I will open it up to questions. I think Representative Leverett has appropriately defined the changes in the bill, and we strongly support it.
All right, any questions from members? All right, I don't see any questions. Thank you. Sure.
One note in closing, Madam Chair. Again, we commend it. In a year when the House of Representatives is focused on property tax reform or tax reform for local governments, I think this is a great step in the right direction. To be paired, as Vivian stated, a fair share or a fair reimbursement. They noted earlier the estimated cost is $80. The state reimbursement is $24. Again, we're just asking for that. It's going to help counties make budget ends, and it's real property tax relief. And we sincerely appreciate the gesture on behalf of Representative Leverett.
Thank you so much. All right, and as requested by the sponsor, Chairman Leverett, we'll go ahead and keep this as a hearing only. Thank you.
We'll be back, Madam.
Okay, we'll do. We will. All right, the next bill is HB 1076, Representative Earhart. Thought I saw her. Okay. Okay.
Thank you so much, Madam Chairman and members of the committee. I have joining me today in support of HB 1076 former Georgia State Senator Chuck Clay, who served for 12 years on the Senate Judiciary Committee. He also served 6 years as a prosecutor for the Cobb County Solicitor's and DA's office, so I'm thankful to have him here for his support. Members of the committee, HB 1076 essentially deals with public safety. It exists for the purpose of protecting the lives and well-being of law enforcement officers as well as members of the general public. This bill would make it a felony to use a motor vehicle to knowingly obstruct, hinder, block, or otherwise interfere with law enforcement officers in the discharge of their official duties. Currently, this offense is prosecuted under the more general obstruction law found in Code 16.10.24. It's currently a misdemeanor and makes no distinction between obstructing with the body and obstructing with a 3,000-pound motor vehicle. The reason for carving out obstruction with a motor vehicle from the general obstruction code is because of the dramatically enhanced risk of danger and personal injury associated with injecting a 3,000 to 6,000 pound vehicle into a police operation. If this vehicle is also driven by someone with the intent to obstruct or impede that operation, the outcome could be dire for both our law enforcement officers and the people engaging in the obstruction. The goal of HB 1076 is to provide an enhanced deterrent to obstruction with a motor vehicle by increasing the penalty from a misdemeanor to a felony. It is likely that many members or individuals who engage in obstruction don't anticipate their actions could eventually end in injury or death to themselves or law enforcement officers. We want to defer this crime before it actually occurs and before death or injury occurs. As with all criminal offenses of this nature, intent, of course, will need to be proven and will be a prerequisite for a conviction of this crime. It is a simple bill. Nothing else in the law changes in terms of prerequisite for intent. It's pretty simply defined. The goal here is to deter and avoid far more serious situations that can occur as a result of obstruction. And I am open to any questions that the committee may have.
All right, thank you, Representative. Mr. Chuck Clay, do you want to say something before we open it up to questions, since you're up here?
My experience in appearing for the House Judiciary over the years, I generally come loaded with two very deep responses: yes, no. So I'll leave it at no, other than thank you for the opportunity for being here.
Thank you. Do you have questions? Representative Penich.
Thank you. Thank you, Representative. Two questions. Don't we have a felony obstruction statute in Georgia?
Only if death or injury occurs as a result. So currently, the actual in code 1016.24, it is subsection A of that is just generally refused to general obstruction, and that is a misdemeanor. Only when violence or personal injury or death are incurred does that escalate to a felony.
So you're talking about a non-touching. I mean, it could be a moving or stationary vehicle as you define it, but it's not harming. It hasn't harmed anybody.
Well, it has indirectly harmed or could indirectly harm. It's a high-risk activity. So essentially what it is it could be a parked car, it could be a moving car. In any attempt, and the goal and the point here in the language in the bill is that individual knowingly is using that vehicle to impede a police operation.
Okay.
Right.
I mean, to me, I think without harm, actual harm, that a felony is a little excessive. But my other question is, where did you get a fine of $100,000? I do criminal defense. I've never seen a fine that high.
Yeah, actually, that is currently in code for other violations of this nature, and that was actually the suggestion of Ledge Counsel. I certainly can make a note to talk to them about that and find out. I know that their original suggestion, based on similar legislation, was 1 to 10 years in prison. We opted for 1 to 5. I think that the concern here and the danger associated with this is that right now our obstruction law is very general. It's just it's kind of loosely defined. What is obstruction? Is it me standing in the way of someone, physically blocking them? The goal here and the reason we didn't have this apply to all obstruction, specifically that where a vehicle, a motor vehicle, is used essentially as a weapon, could be a weapon, to impede or intrude on that police operation. It brings the situation or brings that environment, that law enforcement operation, to a whole new level of danger and risk, not just for the law enforcement officers, but for the folks involved and the innocent bystanders in the area.
All right, thank you. Any other questions from members? All right, I don't see any, and we have 2 people signed up to speak, so I'm going to start calling them. First is Sarah Hunt Blackwell.
Madam Chairman, do you need us to move? For the,
Yeah, if
yes,
you can
yes,
just
yes.
shift.
Yes.
No, we're running out of room here, but.
Thank you.
Good afternoon.
Good afternoon, Chair, Lady, members of the committee. My name is Sarah Hunt Blackwell. I'm Senior Policy Counsel at the ACLU of Georgia. The ACLU of Georgia believes in the fundamental First Amendment right to protest, and it's because of that we oppose HB 1076. Although not directly mentioned in the text, recent occurrences that we've seen in Minneapolis seem to be at least an origin or intention of this bill, and we have strong concerns about actions being replicated here in Georgia that could then implicate a bill of this nature. The courts are clear when it comes to protest and political dissent. Government restriction of protest should be limited and narrowly tailored. HB 1076 is neither limited nor narrowly tailored. However, there is existing Georgia code that satisfies both of these requirements as it relates to obstruction of law enforcement. Code section 16-12-24A, as has already been mentioned, already provides a mechanism that allows for criminal charges against someone who obstructs law enforcement duties. And as this bill is written, a moving or a non-moving vehicle could qualify as a felony. And forgive me if I can to the sponsor of this bill, but protecting law enforcement from a weapon seems kind of hard to fathom if there's a car that is not moving. The existing code section already sufficiently charges someone, whether they are in a vehicle or not, whether they are at a protest or not. So introducing a bill for a crime that is already a crime seems kind of unnecessary. So we ask that you please vote no on HB 1076. Thank you for your time, and I yield for questions.
All right, thank you. Any questions from members? I don't see any. Thank you so much.
Thank you.
And next is Maisie Lynn and Bethany Casa.
Thank you, Chairman and members of the committee. I will not repeat what you've heard before me, but
And I know we all know who you are with.
Sorry,
but
I'm
you
the
are-
executive director. I'm sorry. Executive Director of the Georgia Association of Criminal Defense Lawyers. Bethany Casa is a defense lawyer in Douglas County and our lawyer of the week. So here to provide you all some practice insight if you need it, since I've been out of the courtroom for a little while. My apologies. We are concerned in similar fashion that these the behavior that's been described is already criminalized in our code in ways that are actually more advantageous for what's in issue here. I would agree with the previous speaker that when a car is stationary, it's not a weapon, but when it is used as a weapon, it's an aggravated assault. And in Georgia, that is a 1 to 20 year term of potential in term of imprisonment. It's and it's been, there's no question but that a car can be considered a weapon in that context. Mere hands can be. So there's not really a question that a 3,000-pound car could be as well. I do disagree with the bill sponsor about our felony obstruction code. I do not believe that death is required in order for that to become a felony. You simply need to have knowingly and willfully resisted, obstructed, or opposed a law enforcement officer by offering or doing violence. And then it's a graduated penalty. The first time someone's convicted of that type of obstruction, they're exposed to 1 to 5 years of imprisonment. The second time it raises up to 2 to 10, and the third time it becomes 3 to 15, and every time thereafter it would be the same. Because we feel like with the misdemeanor obstruction that we have in code, that's knowingly and willfully obstructs or hinders is a misdemeanor. If you have done that by offering violence, you now are at a felony. You know, if, as a policy matter, if you're concerned with situations where cars are involved, which I could understand why you would be, perhaps sliding it in the middle of those two as a high and aggravated misdemeanor might be a compromise position to take, simply because, you know, we can appreciate how when a car is introduced into any situation, there can be some misunderstandings about what's happening. But because if it is actively moving toward a human being, you have moved squarely into an aggravated assault posture, that's covered, and it's actually, you know, a higher penalty than what you have in the felony obstruction code section. But if it is stationary, perhaps it would have otherwise been just a traditional misdemeanor, but by making it high and aggravated, you have, you know, found this middle ground. And, you know, we talk frequently in this space about what prevents crime in our country, and the evidence from research that's done time after time is not that we increase penalties. People are generally not aware of the penalties. I would imagine if I polled this room that people here would be very surprised to know that every moving violation in our state is a criminal penalty for which they could serve up to a year in jail. I won't ask them to show their hands, but I bet there are some people in here that would be shocked to find out that if they are pulled over for speeding, that they not only face a fine, but they could go to jail for 12 months. It's not stopping any of us from speeding, because I bet I also, if I asked every, you know, valid driver in the room if they speed, they'd probably all say yes if they were being honest. So we know that fear of penalty is rarely going to stop someone. What is going to stop them is fear of getting caught. So again, just, we don't believe that this is necessary, but if you do, and it's a policy matter, that's certainly your decision to make, not ours. We would ask you to consider this compromise space of making it a high and aggravated misdemeanor rather than another felony.
All right, thank you. Bethany Casa, do you want to add anything?
I'm sorry, I did have one more thing to say before that.
Sure.
With respect to the fine that Representative Panich asked about, we do see fines of up in the code. It's laid out as up to $100,000, but it is in crimes like human trafficking and drug trafficking. You all might remember, I believe it was just last session that you considered a bill where we enhanced some of the carceral measures around fentanyl, and in that, the lowest, and it's still very aggravated, but the lowest level of fentanyl possession is an up to $100,000 fine. Human trafficking, labor trafficking, that's the space where we see that sort of language where you cap it out at that high a number. But it's rarely on a felony that exposes you to something like 1 to 5 years. In fact, I don't believe it's tied to any felony with this kind of prison exposure, and potentially subject to an 8th Amendment violation for excessive fine, because it would be disproportionate to the behavior.
Okay. Do you want to add anything?
Yes, just
Sure.
briefly. Thank you for your time. I just want to add, in respect to the intent, if someone is intending to move the car towards the officer, that is covered under another law, under aggravated assault, where it is a mandatory minimum of 3 years as well. So I would just add and reciprocate that it is, you know, gratuitous at this point, since it's already a crime. So thank you.
Yeah.
Okay. All right. Any questions from members? I do not see any. Thank you so much.
Thank you.
All right. I think, actually, one more. I'm sorry. Blake Feldman.
Just, we oppose it for the same reasons that have been said.
With Gactel? Okay. Thank you. And thanks for keeping it short. Thank you. We like that. All right. If I can get Representative to come back, and then I'll just give you 2 minutes if you want to close it out.
Thank you, members of the committee. And just to be clear, am I on?
No.
Oh, I'm sorry. Yeah, go ahead.
And just to be clear, we want to be very, very clear that nothing in this bill impedes upon the right of citizens to protest, to peacefully protest, to object. There's absolutely no deterrent there whatsoever. In fact, the only thing this bill does is escalate the penalty for this crime from a misdemeanor to a felony. The same burden of proof to prove intent exists in this as in any other criminal violation. Truth be told, essentially what we are seeing here is in this particular environment where we have lumped all obstruction together in one law. As I said before, that could be something as simple as impeding with your body. When you interject a motor vehicle, you elevate the risk of that situation. Damage can be done, harm can be done. As the law exists right now, as a misdemeanor, a person who drives their car into a police operation and impedes or interferes or blocks with that lawful police operation, impeding upon those police officers and the lawful as they are engaging in their lawful activities, you are elevating the risk of that environment to something far more serious. So it's very different when you're talking about a motor vehicle than you're talking about just an average obstruction charge. So we do feel that this is something that is going to protect both our law enforcement officers and the public and anyone engaged in the activity. But to be very clear, we don't feel that currently that this misdemeanor charge of a $100 fine for driving a motor vehicle into a police operation is any kind of a deterrent. And on the contrary, from what we have read, the potential for a felony conviction can have a dramatic effect in terms of deterrent for many types of crimes. And this is one of the more serious ones. So I don't have any other comments right now. I would ask for the committee's favorable consideration, unless our former Senator Chuck Clay has any additional comments he'd like to make.
No, I would like to say that maybe we're always thinking about what's happened recently in various cities, but it is not infrequent in Chicago where folks with no relation or they're not co-conspirators and they're not co-defendants see police activity and then go out of their way to obstruct it. And that may be an armed robbery, that may be a drug deal, that may be resentment of the police, that may be a fellow gang member, that may be somebody you know from the neighborhood, and it does create an incredibly volatile situation. So I try not to have any legislation bearing specifically on one set of facts that we've all read about over the last month going on in the state of Minnesota. This is sort of real world practical stuff, street enforcement, street cops trying to do and protect and arrest the bad guys are impeded by folks often with no association with the underlying event. They don't like the cops. They want to get in their way. Bad guy gets away, or somebody even more tragically gets hurt. So,
all right, thank you. Okay, I will entertain any motions. All right, we have a move to pass. Is there a second? All right, we have a second. Any discussion? No discussion. So all in favor of House Bill 1076, say aye. Aye. All those opposed, say nay. Nay. All right, and I think that's 3-2, so it passes. Representative Earhart, I would, if I may, would like to see if you can get with Gactel maybe about the high and aggravated portion, maybe the fine. If there's additional conversation that could be had, I think that would be great. Thank you so much. All right.
I've been greatly honored.
Thank you. Thank you, former Senator. Thank you. Okay, we have the last bill left, SB 74. If we're going to go ahead and take a quick 5-minute break. I don't think the author of the bill is here yet, so we'll take a 5-minute break. Thank you. All right, we're back. So, SB 74, Chairman Burns is actually having a committee meeting that he chairs, and he is testifying. So we've already heard this bill before, and so out of respect for everybody that has traveled here today to testify, we're going to go ahead and start the testimony. Hopefully, Senator Burns will join us after and if his committee ends. But I would like to go ahead and have our committee hear from all of you who have signed up, okay? Because of the fact that we have 3 pages of people who have signed up. It's more than we've seen in a very long time. I am going to limit the testimony to 3 minutes per person. So please, I'm going to have a stopwatch that's going to go off at 3 minutes. So let's, we can be respectful so that we can be heard. We can have everybody be heard today. Okay. All right. So the first one, is this the first page? Yeah, is Martha Scoggin. Can you do it? Yeah, okay. When she starts talking. Yeah, sorry. Hello. Pick, it doesn't matter whichever mic.
Okay, thank you,
Sure.
Madam Chair and Chairman. I would like to know if I could give you this to hand out to the members.
Yes, ma'am.
Okay. I'd like to start off with a few statistics here. I did some research and found out that we have approximately 5,000 full-time paid librarians and library staff in public and school libraries. We also have approximately 1.85 million students in K through 12. So our librarians represent about 3% of this group. And one of the things that I would like to mention that for 42 years, our students have not had protection from Georgia's obscenity laws. That's because of the library exception law. And my question is, who's advocating for all of these children? I know that there's a lot of librarians here today. There's probably representation from ACLU. But what I want to know is, aren't adults supposed to protect children? We've seen recently, in the past few years, we've seen surges in teen suicide. We've seen childhood anxiety and stress issues. We've seen a large uptick in gender dysphoria. And one of the things that I want to make perfectly clear is our goal is not to jail librarians. Our goal is to protect the innocence of our children, protect them from age inappropriate, sexually explicit, and pornographic materials. Once a child's innocence is gone, you can't get it back. You can't retrieve it. I would like to, if I've got time, I'd like to talk about what's in that packet I passed out. And I gave instruction on how I found this information. That's the first page.
If you've got about 40 seconds, but yes, thank you.
The second page is It's So Amazing. This is found in public school libraries ages 5 to 11, K through 5. In public libraries, the majority are in the juvenile section. Clap When You Land, the second piece of paper, is in grades 6 to 8, ages 11 to 14. In public schools, the majority are in the young adult section. A Stolen Life, that's the third one. Those are found in high schools. And in the public library systems, the majority are in adult biography and adult nonfiction. So there's a huge discrepancy in how books are displayed between public and school libraries. And this all goes back to what is age appropriate. I think I don't think it's rocket science myself, because we have experts who have told us, and if you look at one of the pages in there is age definitions, our court system has defined a juvenile, depending on the state, from age 6 to 8 or maybe from age 6 to 12. Young adults has been defined to 18 to 25.
Thank you.
And
And
my
your time
time's
is
up.
up. Thank you so much.
So
Thanks
that's
for coming.
just things to think about. Thank you.
All right, Rhonda Thomas.
Madam Chairman, could I ask for this to be in the record?
For
my comments?
everything is all on record. Everything is all recorded.
I'm going to switch spots with David. Is
Um,
that possible?
Davis. David Davis. Okay, sure. Go ahead. Do you want to speak or?
Just speak in his spot. If there's still time, that would be great.
Okay, sure.
I didn't know I was only going to get 3 minutes, but I'll try and do this in 3 minutes.
All right.
Okay, my name is David. The following account that I'm going to give you is the first time I've ever read this aloud. This was the most traumatizing event that myself and my family have ever been through. 2 years ago in 2023, our 7-year-old youngest granddaughter, she was 7 at the time, she was sitting in our living room on her iPad. I was on my iPad. She got spammed. I knew that because immediately afterwards I got spammed. She was on a platform, it was YouTube, by some very, very pornographic XXX video. It was immediately extremely traumatizing to her. She jumped up off of the couch. She grabbed her face like this. She started screaming. She was crying. Her Nana and I did not know what was wrong with her. We finally got to a state where she could tell us that she saw a man who took his skirt off and was naked underneath, and she couldn't get past that part. That was the most she could tell us. This rapidly escalated into 4 continuous months, day and night, of some of the most traumatic emotion I've ever seen come out of a child. She continuously cried. She wouldn't have anything to do with me. I represented the male figures that she saw in these pornographic videos. I couldn't hug her. I couldn't kiss her. I couldn't get next to her. She took it to school. She was asking very intense questions of the teacher's aide, the teacher, about things about boys and genital parts of boys that she should have had no knowledge of, much less discussing or asking questions of. It was an absolute emotional roller coaster for her grandmother and I. She lives with us most of the time. It was always nonstop, Nana, I have to ask you something. Nana, I have to tell you something. Nana, I have to ask you something. Nana, I have to tell you something. We couldn't get her to bed on time at night. She'd stayed awake. She's praying out loud. We have her in a Christian school, have since kindergarten. She's praying out loud at night. She is an emotional wreck, and she's only 7 years old. She's just a little girl. She's used to playing with her dolls and riding her bicycle, and she couldn't focus on any of that. Fast forward, I will tell you that as Christians, we were on our knees, her grandmother and I, and her mother, her sister, her older sister, we were all praying to God 6, 7, 8 times a day, begging God to clear her little mind, because that was the only thing we knew that would restore her little mind back to an innocence, and that's what it's really about. She had her innocence taken from her. We eventually was able to get her into some Christian counseling with prayer, a lot of Christian prayer for her. She's, fast forward, here we are today, 2 years later. She's doing better. She's been able to have a pretty normal school day, home life. But she had a resurgence of all of this came back to her about 4 months ago. It just re-erupted. All came back to the surface. We went through some of the same things. Tremendously emotional for our home. very highly emotionally charged household. We're talking about a little girl that's pulling on her face, I just want to die. I don't, she's praying at every meal, she's praying at night. You know, we've taught her to ask Jesus to help her. So every day is a different day. It's a different, you know, every day we're asking our Lord and Savior to clear this child's mind and restore her innocence. I think our primary concern at this point is that we don't know how this will affect her long term. We don't know what we're in store for when she becomes a teenager, which will be, you know, most of us as parents and grandparents know those are the more rougher years sometimes, and certainly how it might affect her as an adult. We just don't know. The point of telling this story is this is a very, very realistic story for my family. It's extremely impactful, has been, and I have long supported SB 74 because we as a family have firsthand knowledge. We have lived what pornography and things that are inappropriate for children to see, hear, watch, listen to, read. So I'm asking you to please consider what we're after here. We're trying to protect the innocence of our children. This is not about arresting librarians.
Thank you. If you can wrap it up.
I am
Your time
finished.
is
I am finished.
Good. Thank you so much, and thanks for sharing your story.
Thank you.
you. Priscilla Bence.
Thank you, Madam Chair.
Yeah, good afternoon.
My name is Priscilla Benz. I'm from Martinez, Georgia. I was an RN for 36 years, and 16 of those years were in the U.S. Army, retired major. I had 13 years of making home visits on families with abuse, and a lot of that was connected with addiction of all kinds, alcohol, drugs, gambling, pornography. My greatest concern right now with not passing the bill is the conflict that we've created for many of the librarians, because right now the law is not on their side. And I know 6 librarians, 4 of them are strongly in support of Senate Bill 74. I don't know that they'd be here jeopardizing their job. 2 of them are on the fence. So the vast majority of librarians who want to do the right thing for families and children, of course, are for 74. And it would clarify for them that they can protect children and parents. That's what most people want. 70% of Americans don't want this material in the children's sections of libraries. Right now, we have a conflict. They have to choose between their career and livelihood or doing the right thing. They need the support of a common sense law, Senate Bill 74. One example comes from a friend of mine, Gay Stone, in a rural county. She's been working 28 years to get this stuff out of the library, and she's actually convinced the superintendent and administrator of the library and the school systems to use takebacktheclassroom.com, and they started doing it. However, when I go on the internet, all those books are still there. Anywhere from 10 books to 400 books are in almost every single library in the Pines system. We have 267 Pines libraries in Georgia. 263 of them in the teen rooms have these sexually explicit books. So evidently, these courageous leaders in at least 2 of the rural counties that I know, they are taking a chance, taking some of these things off the shelves. But again, they're on the internet, so they're having to lead a double life. But there are many reasons to pass Senate Bill 74, many, many. I'm going to have to cut my 8 reasons down to 2 or 3 here. But early introduction to explicit sex leads to early sex and all the societal problems that come with it, including sex crimes. We know that for a fact with research. Senate Bill 74 will go a long way in supporting parents and citizens challenging books. Right now, it's impossible. You can challenge books all day long, and you might get one out of 10 or 20 books that might move from the teen room over to the adult section. And then what I found when I looked at the books that were moved in our library system, we got new library staff, we got a new administrator, we got new library board, we had ordinance, age appropriateness. What happened? 40 books moved over to the adult section, 123 came in. And now we have 334 books in the teen room. whereas there were 40 a couple years ago. So the onslaught is just constant and increasing. Senate Bill 74, if passed into law, would reduce the number of sexually explicit books in our middle school and high school libraries. Right now, they all have some books with them. In fact, I brought excerpts from 32 of them that any of you who are on the fence or would like, I brought the big packet for you. We want to reduce sex crimes down the road because a person's more likely to be a victim or a perpetrator if they've been early introduced to pornography.
Thank you so much.
Yes, ma'am.
All right, the alarm is going to get louder and louder. Mike Griffin.
Anybody want my packet?
Sure. Here you go. If you want to hand it to me, we'll go ahead and get it. Thank you. That's strong. All right. Is this just one? Oh, you have several? Okay.
For people that want it.
If you want to just put it up there, we'll go. If you want to put it just right there, that's fine. Yeah. Thank you. All right. Sorry about that. Mike Griffin.
Thank you, Madam Chair. My
Thank
name
you.
is Mike Griffin. I'm the Public Affairs Representative of the Georgia Baptist Mission Board. And this is my 19th year down here. I was down here when you were here, started. And so I've been representing Georgia Baptist my 13th year. And I do want to say on behalf of Georgia Faith and Freedom Coalition, Mac Parnell is not able to be here today, but he wanted me to remind or let y'all know that they do support Senate Bill 74 and the work that Senator Burns is doing, and we do stand with them in that. Again, being down here 19 years and, with Georgia Baptist 13, and I look at the different areas that I work with representing the Georgia Baptist Mission Board, which we represent 1.4 million Georgians and over 3,400 churches. So you put us together with our Catholic friends, we represent about 25% of the population, 10% Georgia Baptist. And we passed a resolution in 2021 entitled Removing School Library Obscenity Exemption. So this is my 6th year testifying on behalf of Georgia Baptist related to library, obscenity exemptions here. So we are definitely behind this legislation. I covered public affairs ministry. I cover child protection policy for Georgia Baptist and religious freedom. We work with Alliance Defending Freedom. And we work with Greg Love with Ministry Safe. And I have just taught 6 classes in all the regions of the state of Georgia on child protection policy. And one of the things that we have to understand is that we're living in a day when a lot of our kids are being exposed to pornography. The data I've seen from 9 to 10 years of age, they're being exposed to that. And in 2022, Greg Love sent me some information in 23 about the first time ever in the United States of America, 52% of the child sex abuse was peer-to-peer. Think about that. We usually think it's adult to child. Now in 22, it was 52%. It was peer-to-peer abuse. Why is that? I'll tell you why. Kids are being exposed to pornography at such an early age. Don't be surprised that what they see or what they're hearing in these education classes, they're going to try it on somebody else. And so, and working again with child protection policy that I work with Georgia Baptist, it's so very important that we, deal with limiting this types of access because it's creating perpetrators that are out there that are trying to go after kids. It's kids that are messing with other kids. And it's just having such a negative impact on our society. So it's very important that we stand up and we support this. Let's be quite honest, this is a no-brainer because I could hand this same material out on the street and I'm going to get criminally charged. See, the alarm will go off if I did that. And but if I hand it out, if they get it in a library, it's okay. And so, again, Jesus said in Luke chapter 17, verse 2, it's better that a millstone be tied about our neck and tossed into the deepest part of the sea than to cause one little one to stumble. So I hope you'll support this legislation. Thank you, Madam Chair.
Thank you. All right, Sarah Hunt
again.
Hello. And just to the members, if you have any questions, feel free to ask any questions. I know I'm kind of moving through it, but of course we all have the chance to do that. All right.
Hi, again, I'm Sarah Hunt Blackwell, Senior Policy Counsel at the ACLU of Georgia. I testified against SB 74 multiple times last year, and I'm glad to be here this year testifying again. Chairman Burns isn't here, but I would like to thank him for working hard to keep this bill going. The ACLU of Georgia maintains our opposition to SB 74 because it still imposes unreasonable pressure and criminal liability on librarians and expands liability beyond librarians. The language in SB 74 mirrors language included in the referenced code section 16-12-103, which by removing the exemption in section 16-12-104 implicates anyone who provides books at public libraries. So this means book fair staffers, members of PTA, participants in a school-sponsored book swap, literally any person who is providing books in public libraries. This is extremely dangerous and far-reaching provision. This bill deputizes librarians as agents of government-sponsored censorship, creating a chilling effect on the availability of literature and other materials in libraries. SB 74 essentially puts librarians in positions where they would have to initiate book challenges or keep an eye on book challenges, even on content that is merely disfavorable. Based on open records requests that the ACLU of Georgia has conducted on book challenges in libraries across the state, there are typically only a handful of parents who consistently submit book challenges, most of which are submitted without the parents having read the book in its entirety. And sometimes they haven't even read the book at all. Also, unsurprisingly, the majority of the challenge books feature stories and/or characters who represent minority communities. Librarians should not face criminal liability because a vocal few do not agree with the presence or placement of certain books in our libraries. Processes currently exist within our library systems that determine whether and where books should be placed. Those systems are effective in protecting children, maintaining their First Amendment rights, and safeguarding our beloved librarians from criminal liability. We ask for this committee's no vote on SB 74. Thank you, and I yield for questions.
Thank you. No questions. And you are under the time. All right. Next is Charles Pace.
Thank you, Madam Chair. I am Charles Pace. I'm the Executive Director of the Gwinnett County Public Library. I want to thank you all for giving me this opportunity to speak to you today regarding Senate Bill 74. As a parent and grandparent, I share with all of you a strong desire to keep our children safe and to protect them from harm. However, as a library professional, I have grave concerns regarding the potential impact of this bill should it be enacted into law. There are many things in life that may seem right, that may seem like an unalloyed good, but that frequently have unintended and negative consequences. Historically, libraries and librarians have been exempt from legislation such as this because the state of Georgia has recognized the critical role that they play in providing information with a wide and diverse range of viewpoints, including materials that may be considered controversial or sensitive in nature, and to do this without fear of prosecution. If libraries are not exempt, this may have a chilling effect, as many libraries will seek to remove any material that might be considered controversial in order to avoid accusations of impropriety under the law. Library users have many reasons for requesting certain types of information, including for personal and scholarly research, or to help deal with personal issues and trauma that they may be facing. I agree, not every book is appropriate for every child, but it may be appropriate and necessary for some. Georgia libraries currently provide excellent service to the citizens of our great state with very few issues or complaints. It would be a sad outcome if we allow fear to impair that mission and/or compromise service to our communities. Library staff, and I think I can speak for most of us in the state, believe that the authority for choosing appropriate materials for children lies with parents and/or guardians. It is not the place of library staff to make judgments about what books a child is allowed to borrow. Typically, young children will be accompanied by a parent or caregiver when they visit the library, and most libraries, including Gwinnett, do not allow younger children to visit unless they are supervised by an adult. Furthermore, as a practical matter, most libraries are not organized in a manner that allows children to be restricted from adult areas of the collection. Adult materials are often used by older teens for school-related research. In addition, in the case of Gwinnett, 100% of our materials are checked out using self-check machines. These transactions do not require any staff intermediation. Finally, I would be remiss if I did not point out that most teenagers today carry smartphones that allow unfettered access to a variety of salacious and inappropriate content. With all of that material privately, are they really going to go to the library looking for something inappropriate? I find it unlikely. Therefore, for these reasons and with the context provided, I urge you to vote no. Thank you for your time and consideration and your past generous support of Georgia Libraries.
Thank you so much. And that was right on time. Mary Miller.
Hi, my name is Mary Miller. I'm a resident of the city of Kennesaw. I am opposed to Senate Bill 74. Librarians are professionals who develop collection development policies that should be approved by their boards. These policies include processes for a parent or community member to object to library materials and a process for the reconsideration of that material, resulting in its removal or retention. I believe that threatening librarians is a thinly veiled attempt at censorship by intimidation. I believe children should see themselves reflected in some materials, as well as learn about lives, peoples, and cultures that are different from theirs, so that they can become discerning adults. Parents or guardians also have the right to decide what's best for their kids. I also believe freedom of information is critical for a healthy democracy, which I think we all believe is a good thing still, right? Let's support freedom of information, a strong educational system, freedom of thought, parents' rights, and our librarians who are trying to do their professional best to uphold all of these things. Thank you.
Thank you so much. Susan McWethy? Hello.
Hello. Hello. I'm a retired middle school librarian, and frankly, I'm appalled at the provisions of this bill for more reasons than time will permit me here. So I'm going to just focus on the dangerous result to librarians this poorly written, contradictory, and unenforceable law will impose on them. Georgia Code 16-12-102, on which this bill is based, clearly contradicts itself. Part C under harmful to minors defines harmful as lacking in serious literary, artistic, political, or scientific value for minors. But paragraph 7 defines sexually explicit nudity as, quote, a state of undress so as to expose the human male or female genitals, pubic area, or buttocks with less than a full opaque covering. Doesn't human anatomy come under the category of science? Are librarians expected to inspect and likely remove all books in the 500s and 600s that contain chapters on human anatomy with descriptions or representations? Libraries are expected to support, school libraries are expected to support the curriculum. How does this law support science classes covering, for example, human sexuality? Librarians are caught in the middle, and now they could be criminalized for misinterpreting a bad law. The same Part C does not mention anything about the social value of literature to minors. This can be read to mean that our children are allowed to access books dealing with the normal challenges of adolescence and life, such as addiction, sexuality, gender dysphoria, or self-confidence. Books for which children at vulnerable stages need good information. But somehow I feel that these very topics will be under attack by the censorship police, again placing librarians in impossible situations, whether to follow their professional expertise or capitulate to others who have narrow agendas and want to foist their ideologies on everyone else. And just how does a librarian prove good faith effort? This is an example of authoritarian overreach, which is apparently manifesting in the state of Georgia's libraries. Keep the government out of our libraries.
Thank you. All right, so I see Chairman Burns here. Chairman, thanks for coming. I know you had a committee meeting yourself, but I'll just give you a short time to, I know we've been hearing some testimony, but I will give you time to present your version, I believe. We want to make sure we have the right version, and if you want to explain the specifics, and then we'll go back to testimony.
Thank you, Madam Chair. Thank you, committee. I apologize for having a few conflicts this afternoon, but I am very grateful that you're willing to hear the bill, Senate Bill 74, which was in this committee last March. And what I have here is a form of the bill that was worked out with Chairman Smith. I'm working off of LC 1607S. Please look carefully. So this is my understanding, this would be a committee substitute.
Does everybody have it?
For
We just
Senate
passed
Bill
it out.
74. Is that the correct version? You have that? Okay. Thank you.
Thank you.
Let's do a few brief preliminary statements, and then we'll quickly look at the bill, which is very, very straightforward. And I started this presentation last year with the same comments. I love libraries. I love librarians. I spent a career in education. I wish every student would read vociferously, and I do not wish to put limits or bounds on their material. Having said that, we seem to not be able to differentiate between adolescent material and adult material. And I think it's important for us to understand that this bill does not ban or eliminate any material at all. It does not ban any book. It does not require that any material be removed from the library. It requires that a good faith effort be used to place and catalog it in an appropriate place in the library so that it would not be accessible to minors without parental oversight and supervision, or that the student could not independently check inappropriate material out. The parent can make the decision to then determine what is appropriate for their child, the parent or the guardian. So, if you look carefully at this legislation, it's only about 4 or 5 sentences, and so I'll read them, and I apologize for reading. But I'm going to start with the key provisions in this legislation, beginning in line 13. The provisions of Code Section 1612-103 shall not apply to any public library operated by the state or any political subdivision or any library operated as a part of the school, college, or university system if the person, subsection 1 in line 16, was not aware that such harmful material, number 2, had previously suggested or recommended, warned, or otherwise communicated that such harmful material at issue be considered for a book challenge or an obscenity review by a relevant commission or group within the library, school system, university, or other relevant body. And finally, had suggested, recommended, or attempted to have such harmful material at issue moved to a different location or signed a different permission set within the library or online system for which that would not be reasonably accessible to minors. So, there's no language in the current version of the bill that calls for a penalty to a librarian. There's no provision in the bill that even says that the librarian intentionally did something wrong. Indeed, it simply says that a librarian will follow the same law that you follow, that I follow, that every teacher in public school follows, that every police officer follows. So the interesting thing is, Georgia law already codifies the reality that it is a crime to give harmful, sexually explicit, obscene material to a minor. And what we're doing with this legislation is removing the exemption, because the exemption makes no realistic sense, since every Georgian must follow Georgia law. So, at the end of the day, other states have attacked this challenge. Some have been successful, some less so. I fully anticipate that if this were to become law, there would be certain entities who would challenge it in court. And with the anticipation of that, in partnership with the House committee and with the chairman, this is the recommended language which I feel is sufficient to achieve the objective. And the objective is simple: protect children from harmful material. I'd be happy to entertain questions. I'd be happy to listen to public testimony. I believe the committee, those of you who were a part of the conversation back last March of 25, we heard from a large number of people both in favor of the legislation and opposed to the legislation. But if I look at it, I would say I have a hard time understanding why people oppose protecting children. That's where I am. I'm happy to respond to questions.
Thank you, Senator. Any questions from members? I don't see any questions. I'm going to go ahead and continue with our testimony. Thank you. And just as a reminder, you cannot record videos in this room. Everything is already being recorded. You can always go and watch it again on our legislative page, but please don't pull out your phone and record this meeting while we're in here. All right, next on our list is Anna Musa. Anna?
You wanted Susan. She's given her time to Susan. I'm sorry, Susan Fisher.
Okay, Susan Fisher. Does Anna want to speak? Okay.
All right. It took 3 minutes and 29 seconds when I did it at home.
If we can, maybe we can talk a little faster.
I will.
Get at 3 minutes. Thank you.
Okay, I'm going to talk fast. All right, I'm a new resident of Georgia. I moved here about a year ago from California. And while in California, I spent most of my adult life working to assist victims of crimes. So I might have a slightly different perspective on this issue. I was the director of a large 501c4 where we helped write and pass tough on crime pro-victim legislation like 3 Strikes. Over a period of 20 years, we worked with and assisted thousands of victims of all different kinds of crimes, including sexual assault, child molestation, and trafficking. Later, I served as the chair of the California Parole Board, where I conducted nearly 1,600 lifer hearings and probably a couple of thousand parole revocation hearings for people who had been paroled and who had reoffended. Excuse me, I'm apparently losing my voice. I also worked as a victim rights advisor for Governor Schwarzenegger while I was in Sacramento. I worked with every agency that dealt with crime victims, all the community organizations like the Rape Crisis Center and the Coalition Against Sexual Assault. So I'm very familiar with issues related to victims and with the people who commit those crimes. Many of the inmates that I met, and particularly when I was doing revocation hearings with inmates who had been paroled and reoffended, talked about using pornography prior to their crimes. In fact, many of them talked about using pornography from the time they were young children. Many of the victims that we dealt with talked about being given explicit materials as a means of grooming them for abuse. Clearly, everyone who looks at pornography isn't going to become a child molester, but research does seem to point to a correlation, and police say, as Mike mentioned, that there's a rise of child-on-child abuse that's being fueled by access to pornography. I became aware of this issue shortly after I came to Georgia. As a grandparent to 5 children living here, it's an issue that concerns me. And while some people seem to believe that the books in question don't rise to the level of pornography, there's really no reason that children should be exposed to sexually explicit material for any reason. We should be protecting the innocence of our children. We provide interventions and support for kids that have difficult life situations. Giving them wholesome, age-appropriate reading material is an important part of that support. So I hope that you will consider voting yes on SB 74.
Thank you so much. Michaela Arcega?
Good afternoon, Madam Chair, members of the committee. Thank you guys so much for taking the time to hear from us. And I do want to first say thank you to the chairman and Chairman Smith and other members of the committee who I know have put in a lot of input on this bill. This new LC is, we think, a substantial improvement over previous versions that we've seen of this bill. But we do still oppose this type of legislation on principle. We do feel that it is going to create this cooling or chilling effect on access to literature. My name is Michaela Arciaga. I'm the Georgia Advocacy Director for the Intercultural Development Research Association. We also coordinate the Georgia Education Justice Coalition, which is made up of hundreds of members from around the state, including students and parents and teachers and librarians and school counselors who have many concerns about this bill. I don't want to duplicate anything that you have heard and will hear from other speakers, but I do want to frame a significant concern that we have about this bill and bills similar to it, leveraging this definition of obscene and harmful to minors. We firmly believe, like many others here, that every child deserves to feel represented and valued, and that one of the ways we protect children, particularly those who are gay and lesbian and queer, is by showing them as whole humans and desexualizing their community and literature and media as part of our community and society. With that in mind, we are concerned about a section of the code that this bill leverages, which is OCG 16-12-102. It is the preceding section. You should potentially have a copy of this definition in front of you, which is this definition of harmful to minors. It includes the section on sexual conduct, where the definition of sexual conduct is actual or simulated acts of masturbation, comma, homosexuality, comma, sexual intercourse, comma, or physical contact in an act of apparent sexual stimulation or gratification, etc. Our major concern is this inclusion of homosexuality as a blanket term for sexual conduct. Our understanding is that this definition, as written, would apply to any act of homosexuality in media or literature, not just intercourse, but 2 men holding hands in a picture book, or 2 women kissing while making dinner in a chapter book. And our concern is that as this definition would unintentionally capture an entire aspect of literature that I don't think is the full intention of this body or the author. We have raised these concerns to the author as well as other members of this chamber on both sides as similar legislation has come up. But we would encourage the committee to resolve this aspect of the code and avoid the specific act of censorship that this legislation will entail by voting no to SB 74. Thank you.
Thank you. Tripp Richardson.
Good afternoon, Madam Chair, members of the committee. My name is Trip Richardson, and I'm with Frontline Policy Council. I want to thank Senator Burns for bringing this bill forward and to the committee for taking the time to hear it. This bill is about protecting children and preserving their innocence. Parents and families expect that libraries, especially school libraries, will be a safe, age-appropriate environment for minors. SB 74 helps ensure that expectation is met by preventing children from being exposed to sexually explicit or harmful materials in these very places. Importantly, this bill is consistent with long-standing Georgia law. Our code already recognizes the state's compelling interest in protecting children from harmful material. SB 74 simply ensures that schools and libraries, where children spend a significant portion of their time, meet that same standard. The goal is consistency and accountability, not punishment. For these reasons, Frontline Policy supports SB 74 and respectfully asks for the committee's favorable consideration. Thank you.
Thank you so much. Lindsay DeFrank? DeFrank.
Hello. My name is Lindsay DeFranco. I live in Milton, Georgia, and I'm here just as a parent to speak in opposition to this bill. I could argue the merits of this bill, how it's vague, or how it's unenforceable, or how a federal court struck down a nearly identical law in Arkansas. But I think the people who support this bill already know this. So what I really want to ask is, what is the end goal? Because in my opinion, this isn't about protecting children. It's about legislating morality through the tyranny of the minority. It's about imposing one group's definition of what's acceptable onto every family in Georgia, and that's not your job. You say you're the party of small government and you say you trust parents, then trust us to know what's good for our kids. We already set limits for our own children, and we don't need the state to have the power to veto what your children or what other children can read. We don't need the state threatening librarians with jail time to do our job for us. That's not small government, that's government overreach. Libraries in Georgia already follow careful, established processes for selecting materials. Trained professionals use established guidelines to choose age-appropriate books, and those systems work. This bill throws all of that out and replaces it with fear. Librarians will pull books not because they're harmful, but because they're controversial. You don't have to burn books to destroy a library, you just have to make librarians afraid. And here's what really frustrates me. We have a literacy crisis in this state. Our phones have video games, we have TikTok, we have YouTube. They have endless distractions that are vying for their attention every single day. And when a child walks into a library and actually wants to read a book, that's something we should celebrate. That's a win. Instead, this bill attacks the very people who foster that love of reading. Wouldn't you rather have kids reading books that have been carefully selected by trained professionals than scrolling the internet unsupervised, where they can access anything with no filter and with no guidance? So I have to ask, do we really have an organic literacy crisis, or do we have an illiteracy agenda? Freedom of information is something that we want celebrated in this country, the right to read, to learn, and to access ideas. People have fought and died throughout history for those. Those who have tried to suppress books have never ended up on the right side of history. Not in Nazi Germany, not in the Soviet Union, and not in the Jim Crow South, where Georgia itself once made it a crime to teach black people to read. Those who censor never think they're the villains, but history always tells us who they are. If we truly want to protect our children, we give them more books, not fewer. We give librarians who can guide them and not librarians who are afraid to help them. We give them the tools to think for themselves and not a government that decide what thoughts are safe. As Frederick Douglass said, once you learn to read, you will be forever free. Please don't take that freedom away from Georgia's children. Thank you.
Thank you so much. Actually, there's a question if you want to wait for a minute. Representative Byrd.
Yes, thank you for your testimony. So I would like to know if you think a book called, let's see, what is it? Looking for Alaska. Have you gotten a blowjob? Let's see, no, let's see, her face are nanometers away from his penis. So do you actually believe these types of books should be in our library? I believe in personal responsibility. I also believe in the proper role of government. And unfortunately, these types of books are in our libraries now. And I think that we, as a state legislature, personally myself, I don't know about anybody else at this desk, we should take that into our hands to make a law, possibly, to remove those types of books, at least into a adult section.
Thank you for your comment. Thank you for listening to what I have to say. If you do want my feedback, I feel like students are exposed to that kind of talk and that kind of content every day anyway. And so, do I think that should be in an elementary school? Probably not. Is it? I don't know. I'm actually friends with the author of that book. I support him a lot. And I think this is a case where it can be on a case-by-case basis, but I don't think that we should criminalize librarians, and I think we should trust parents to have oversight over their kids. Thank you.
You have one more question. Chairman Crow?
Hi.
Thank you. So, just kind of following up on that, do you think that there are materials that are inappropriate for certain age children?
I'm sure there are.
Or do
Are
you
they in
think-
libraries? I don't know.
Okay, no, and I didn't ask if
Yeah.
they were in libraries, but you do think that there are certain materials that are age specific that maybe are inappropriate for certain age children, right?
Sure, absolutely.
Okay,
Yeah.
so then would you also think that it would be appropriate to make sure that those materials that are not appropriate for those kids are put into a section of the library that is specific for people who are not kids? So if I, as a parent, take my child to the library and want to let my child go find books to read, that they don't come across one of those? Because I am trying to keep my kids reading. I'm trying to get my kids to read the right things, but I certainly don't want them to be exposed to that. Don't you think there should be some sort of a barrier or a at least sectioned off area to where I don't have to worry about my children getting exposed to those kind of things in the library?
I'm pretty sure this bill talks about the librarians. I'm not arguing with your point, but I'm here to say I don't think we should criminalize librarians
Well, now,
for
look,
this.
so this part here on section 3, it says that they are not, that it doesn't apply to them, provisions of code section 1612-103. There's 3 reasons that it would not apply to them. One of them would be, number 3, had suggested, recommended, or attempted to have such harmful material at issue moved to a different location or assigned a different permission set within the library or online system that would not be reasonably accessible to minors.
Okay, so what is the question?
That wasn't a question, that was a statement. You said that you thought it was criminalizing librarians.
Yeah.
And it's not. That part right there says it. What you and I just talked about, that there should be certain materials that are sectioned off and put in a reasonably inaccessible area for minors. And so that would exempt them from this.
Okay.
Okay?
Okay.
All right, good. We're on the same page. Thank you.
Well, I don't know about that, but thanks.
Thank you. All right, Judy Kraft. Charlize, I'll send it to you.
Sorry.
I'll send it to you.
We have too many materials. They just fall out. I'm just going to speak a little bit. I don't have a written statement, but my name is Judy Kraft, and I live in Forsyth County. I lived in Gwinnett County for 39 years, and this is not a new issue. And in fact, almost the same legislation was introduced in 1995 by Senator Clint Day. And so at that time, I was part of a civic and moral concerns ministry and went to find out what the controversy was about. And actually, it was, at that time, Gwinnett and Forsyth County were a joint library system. And they split over this book. And it's called It's Perfectly Normal. And I'm going to pass it around for you all to look at. So when I went to the presentation, there were 2 mothers who were making the presentation because one of the 5-year-old twin girls picked up this book in the library. And the mother went to the librarian and said, we think this shouldn't be where children can be exposed to it because they're just, well, I'll let you pass it. I'll let you look at it. I want you to. And then this is an updated version in 2015 of the same book. So I'm going to start one over here and one over here, and just all you have to do is flip through it. So Senator Clint Day introduced the bill, and it passed the Senate, and it was to reasonably restrict children's access to sexually explicit materials. And it did pass the Senate, and it went to the House, and at the time, Speaker Murphy was the speaker. And these excerpts from this book were sent in on the House floor, and the speaker said, someone is sending pornography to the House floor. So it was pornography here, but it was okay for our kids. So we had nothing left to do except go back and work in our counties. And I was part of the co-founder of Citizens for Family Friendly Libraries. And we did commissioner surveys because they're the ones who appoint trustees to the library board. And we had petitions, and it was the front page story, what a year it was, 12 months, and it talked about the book controversy for the whole year. And then at the end, finally the library board changed from 1 conservative and 5 and 4 liberal members who supported, and that the control changed, and the library director was fired. And so actually we have Charles Pace as a result of that, who came later on in the Gwinnett County Board. But one thing that I think from hearing today, there is an onslaught of materials, and it's more than parents can handle. You can't do all the book challenges, and we need help. It is harmful to children, and we have a problem in need of a solution. And I know during the last 3 years, there's been a lot of talk and a lot of people seeking a solution. And I think Senate Bill 33 is a good solution. I think it's very well thought out, trying to take into consideration that there's not criminal penalties for librarians. I honestly think most librarians want to do their job and to be responsible. I'm just saying now there's great momentum. There's probably more than there has been in years. So I encourage you to pass this bill.
Thank you so much. Thank you. Rhonda Thomas, do you still want to talk?
Yes, please. Whoa, that chair's a little lower than I thought. Chairman and members of the committee, thank you for allowing me to speak today. My name is Rhonda Thomas. I am here as a parent advocate, a co-founder of Georgians for Responsible Libraries and Truth in Education. I'm in strong support of SB 74 because the bill does one very simple thing and a necessary thing. It restores equal protection for minors under Georgia law. We too want to protect the First Amendment rights of our children. What SB 74 is and what it is not. It does not criminalize librarians. It does not restrict adults' access to lawful material. 74 simply removes a special exemption that allows institutions, not parents, not private citizens, to provide sexually explicit material to minors without accountability. Every other environment in Georgia is held to a harmful minor standard. Only schools and libraries are exempt. This exemption is what SB 74 corrects. Some believe the bill criminalizes librarians. This is not true. The Georgia law already requires knowledge and intent for criminal liability. 74 does not change that standard. Librarians are not being targeted. Institutions are being targeted and held accountable to the same standard as everyone else when minors are involved. No one is prosecuted for accidentally shelving a book, but knowingly providing sexually explicit material to children should not receive blanket immunity simply because it happens inside a school or a library. What does knowingly mean? It does not mean accidentally, unknowingly or by mistake. Georgia's legal standard for knowingly, under Georgia criminal law, a person acts knowingly when they are aware that their conduct is of a particular nature or that certain circumstances exist. This means there must be actual awareness, not speculation. There must be intentional conduct, not passive presence. There must be knowledge of the content, not just a title or reputation. That is a high bar, not a vague one. What knowingly does not mean, knowingly knowingly does not mean a book exists somewhere in a large collection. A librarian didn't read every page of every book. A book was donated years ago. A digital platform includes thousands of titles. A minor independently searched the internet. Those situations do not meet the legal definition. I'm going to skip forward because I had quite a bit. Parents should just, there's always the comment that parents should just monitor their children. Parents do monitor their children until the system bypasses them. When explicit materials are assigned, promoted, displayed, or provided by schools and libraries, parents are no longer the gatekeepers, the institution is. 74 restores the parent's rightful role by ensuring that schools and libraries cannot override parental authority. Respectfully, that argument assumes that educational value requires graphic sexual content. It does not. Georgia's classrooms thrived long before explicit sexual materials were introduced. I want to share one quick story.
We're out of time. Sorry. Thank you.
Okay, I was going to share about a 4-year-old.
All right.
All right, thank you.
Karen Parham.
Hi, my name is Karen Parham. I live in Columbia County. I'm representing the Freedom to Read Coalition of Columbia County. I am and my organization is in opposition to SB 74. I know I spoke in front of you last year. We still have many of the same concerns just because of what we've seen in Columbia County. What we saw happen, it was sort of an administrative ordinance, and it didn't even have any teeth in it as far as criminal law, but our librarians were essentially forced to move 40 books out of our YA room, and it was based off of an ideological resources. So none of those books, as far as I know, are harmful to minors, and that just kind of shows the sort of pressure that something like this is going to put our librarians under. So that is the real concern, that no librarian, they don't go into being a librarian to, be put in this type of position, right? Like, we're talking about somebody who's making, I don't know, maybe $60,000 a year, right? And you're saying, okay, well, we're not doing this to throw librarians in jail, but these are normally law-abiding citizens, right? Do they want their mugshot up? Somebody comes in and threatens to move a book, or they claim a certain book is explicit. And if they don't move the book, then that's the risk, right? And then that mugshot, the way it is right now, is out there forever. I mean, that's quite a deterrent. So some of the books that have been moved also aren't just YA books. Like, we had a very, very basic sex ed book. I wouldn't even call it a sex ed book. It was, do you all watch Kindergarten Cop? Right? So boys have a penis, girls have a vagina. That was basically this book. Okay, it was just naming their private parts. So that was moved. Like, how is that not appropriate? And that actually, as far as protecting children, letting them know the appropriate names of their private parts, right? And being able to communicate with healthcare providers, actually enables them to report abuse. So that actually protects children. So, and I really have to look at you sideways if you're going to look at that book and claim it's pornography, right? Because to say it's pornography means that it's, what is it? According to the prurient interest, right? Like, you're going to become aroused by it. Well, I mean, I don't know. And as far as that book that you read, Looking for Alaska, I actually read that book because it was challenged at our library, and I just challenged it to have it moved back into the YA section. What is important to know about John Green is he oftentimes, sorry.
You want to finish your
thought
there?
So he oftentimes will, his scenes are meant to be contrasted with another chapter. So he might have one scene, so he's always kind of downplaying the sexual content because he's like, no, that's not what's important here. What's important is the relationships that you have with people. And don't we want our teenagers to have the importance of a relationship? Because they're being exposed to this content. I have 3 teenagers. I can tell you they are exposed to on the bus. They're talking about things like this.
All right, thank you. You have a few questions.
Okay.
Representative Byrd.
Thank you. So I'm trying to find out, is it the librarian's responsibility to teach my children what a vagina and a penis is, and or a blowjob and those sorts of things, as you think that you should be the deciding factor? As far as I know and I understand that me personally, it is a parent's responsibility to teach their child what parts are involved at the age that they think is appropriate. Do you not agree with that?
I agree with that, but like this book, for example, had been in our picture book section since 1999. So, and there were no complaints about this book. It was never complained about. And so I would say no children under the age of 10 in the Columbia County Library System is allowed to be in that library without an adult. People have to watch their kids. I had 3 kids under the age of 4. And somehow, and they all have ADHD, somehow I managed to watch them in the library, because if I didn't, they'd tear the place apart. So, right? So I was able to watch my kids in the library and see what kind of content they were going to come across. I believe in the parents, and I believe in parents in Columbia County are able to do that as well. I've had many parents with different religious backgrounds who have come to me and said, no, it is my decision. And they, you know, it's quite controversial in Columbia County, I'll admit that.
All right, Chairman Crow.
Thank you. You said you had made a petition for that book to be moved back to the YA section.
Yes, that's correct.
And I'm assuming that means young adults.
Yes, I'm sorry, yeah.
Can you tell me what constitutes a young adult in your library? Like, who would be in that section?
So normally,
you said nobody under 10 is allowed to be there without a parent. So a 10-year-old could freely walk into the young adult section.
So ages 11 and 12 are allowed to be in our library system for up to 2 hours unsupervised. And so as far as what constitutes young adult right now, it is from ages 12 to 18. And we have a different room, and it's actually downstairs. It's not so upstairs, because we have 2 floors. So our upstairs is all picture books, easy books, things of that nature. And then you go downstairs, there's a specific young adult fiction room, and then a graphic novel section. So right now in the collection development policy, it's based off of professional reviews. So when a book comes out, and you know, you have different reviewers will review it, like Kirkus Reviews, School Library Journal, and they will give an age recommendation. So that is part of it. And then there's some amount of discretion for librarians as well.
Do you happen to know what the age recommendation is for that book? And I don't know, that literally the only part of that book I've ever heard is what she just read.
Okay. When I last... So if you look, if I remember, and I'm doing this off the top of my head because I just wrote it, but I want to say it was high school age. It was like 14 to 18 for that book.
Do you have any other questions,
No,
Chairman Crow? All right, Representative Penish.
I forgot my question.
All right, we're going to move on. All right, thank you.
All right, thank you so much.
Amy Braggham.
Good afternoon, representatives. Thank you for your willingness to serve our state, and thank you for your continued support of Georgia Public Libraries. My name is Amy Brigham. I am here today as a trustee from the Hall County Library System. I am here to share my concerns about SB 74. As the proud mother of a K-12 homeschool graduate, the homeschooling parent in me is concerned about parental rights and how SB 74 will impact a parent's duty and obligation to guide their own children's reading of outside pressure or oversight from the state. As a military wife of over 20 years and somebody who has made many sacrifices alongside my husband to defend American rights and freedom, I'm concerned about the impacts SB 74 will have on the First Amendment rights of all Georgians and the future doors that could be opened due to the precedent this legislation may set. As a budget-minded voter, I wonder who will pay for the legal defense and law enforcement that will come about upon implementation of these policies. And as the chair for the Hall County Library Board, I am gravely concerned about how SB 74 will impact the community I serve, the patrons who frequent our libraries, and the wonderful staff who dedicate themselves steadfastly to their jobs throughout all sorts of challenging circumstances. All across the state of Georgia, youth literacy is a dire issue. In my county, nearly half of third grade students are not reading proficiently at grade level. It is the job of youth services staff to partner with parents to help to enrich the educational opportunities being provided outside of school, to help inspire children and teens to read and explore their world, and to assist young people as they learn how to research and access high-quality, accurate information both for school and personal purposes. Working in the library is a demanding role, one that requires far more skills and talents than most people realize, and one that also involves many personal risks, as libraries have become a hub for social services in many communities without a good social safety net. Our library staff are some of the frontline troops in the fight against illiteracy, misinformation, and poor educational outcomes. They deserve support and celebration for the tremendously important role they play in our communities, not the threat of prosecution from vaguely worded and difficult to interpret legislation. What's provocative or offensive to one family may be perfectly welcomed by another. Libraries serve all members of a community, even those of whom we may personally disagree. In closing, I urge SB 74 proponents to please reconsider their support of this bill and to stand alongside the hardworking library professionals and educators who seek to expand the minds of children. Together, we can empower the youth of Georgia to have a better, stronger future. Thank you.
Thank you. Mike Cooper.
Thank you, Madam Chair. I'm Mike Cooper, trustee of the DeKalb County Library System and president of the Friends of the Stone Mountain Sue Kellogg Library. I'd like to acknowledge that the substitute version of Senate Bill 74 is preferable to the original measure introduced last year, which would have removed all protection for librarians. But I remain concerned that library staff could still be charged with a misdemeanor of a high and aggravated nature if they do not meet the requirements in Section 1. Subsection 1 is vague and undefined. Subsections 2 and 3 encourage librarians, if they want to protect themselves from prosecution, to urge that materials be considered for a book challenge or obscenity review, even if they know the material is not harmful. This when in doubt, call it out approach would lead to restricted access to material that may be totally inoffensive or appropriate for adolescents who are developmentally ready. Georgia libraries do not purchase obscene materials. I have heard nothing today indicating that they do. A slang term for a sexual act in a book is not obscenity as described in the Official Code of Georgia, Section 161280, unless the material, taken as a whole, lacks serious literary, artistic, political, or scientific value. You've heard from several people today about children's exposure to pornography, including a most unfortunate incident involving YouTube that occurred at home under parents' supervision. None of this involved libraries. None of this involved library materials or librarians. This testimony has nothing to do with Senate Bill 74. These witnesses have confirmed today that the vulgarity, sexual themes, and teen suicides present in society today are not caused by young people going to a library. They get it elsewhere. Finally, I believe any restrictions of this type are best handled locally. The needs and policies of the large counties in the metro Atlanta area are not the same as those in the rest of our state. One size does not fit all. Local library systems are in the best position to determine what is appropriate for their patrons. I respectfully urge your committee not to recommend approval of Senate Bill 74. Thank you.
Thank you. You have one question. Representative Roberts.
Thank you. So, I don't know if we asked this last time. Are there rules on how you divide sections up in the libraries already?
They are categorized, but I don't know if there are. What kind of rules do you mean? I'm not.
Well, I mean, are most libraries dividing into adolescent, young adult, and
yeah, I would say so.
They already are. Okay, so there aren't any sort of guidelines for you all. You just do that based on your own discretion.
Well, the libraries use their expertise to classify things appropriately.
I'm with you. I think you are the expert.
Okay.
I'm just asking. I've heard a lot of
I'm not a
people
librarian.
Well, I've heard a lot of people say they don't want to lock librarians up. I'm trying to figure out if there's some other code section where we can just set guidelines on.
Well, you have a protection that's existed in Georgia law for decades that protects librarians from prosecution. I'm not aware of any problems that have occurred over the years. I have yet to hear any testimony that this person got a book from the library and they were ruined for life, and I don't mean to make light of that because there are negative cultural influences there, but this is not where your problem lies.
I was just trying to.
Okay, no.
Thank you. Chairman Crow?
Thank you. Just a quick question. You said that paragraph 1 on line 16, was that what you were referring to that was vague?
I'm referring to subsection 1 where the person has to be aware of the material. I don't have the copy of the bill in front of me, but
it says was not aware of such harmful material.
Right.
Well, I was wondering what you thought was vague about that.
Because how do you prove somebody's aware or not aware of material? How does a librarian defend themselves against the claim that they were aware of the material because it's in their library? Librarians do their best to survey the materials they have, but they can't read every word in every book, just as I'm sure you don't know every word in every piece of legislation approved under the Gold Dome, but it's...
Sure I do.
Well, in that case, you should be a librarian.
Well, I've already heard earlier somebody said they made $60,000 a year, so they're already about 3 times making what we do.
But no, to your point, I how do you prove that? And I worry that an overzealous prosecutor would say, well, you had to know, you had to be aware, and therefore we can prosecute you. And I just think that's a high risk for librarians who work hard for not very great pay. They're dedicated to the community. They deal with the public every day. I really don't think we need to put this additional concern or burden on them.
So you did say they are the experts, right? And they should be the ones that are really the I hate this term, but the adult in the room, right, when it comes to the libraries. I mean, and that they are the subject matter experts of what is in the literary information that is in the libraries, right? Who else can we depend on? An earlier speaker said that they're becoming a social safety net a lot of times, which means there's a lot of kids that are going there because they have nowhere else better to go.
Mm-hmm.
And I think if a child has nowhere else better to go, a library is a great place to go. They're wonderful places filled by wonderful people, and it keeps getting insinuated that we somehow have this angst against librarians, and I don't think anything could be further from the truth. But if that's the case, and kids are there, how do you suggest we keep them from seeing things that are inappropriate? And we have a definition already in the code that talks about what's inappropriate. Whether that is up for discussion, that's not part of this bill.
No, of course.
That can be another subject for another time, but it's already been determined in previous Georgia law what the legislature has thought was inappropriate for minors. How do we reconcile that?
Well, I hear what you're saying, and I understand the concern. We in Stone Mountain see a bunch of school kids come after school and hang out in the library, and they're unsupervised. But it's not up to us as a government body to control the young people if their parents are going to allow them to be there. If the parents knowingly allow them to wait at the library, and if a parent has concern about the contents in the library, they should just accompany their child into the library when they're there. But I don't think you can put a harm or a negative aspect to the libraries being there for kids coming on their own, because I can think of a lot worse places for them to be. And I'll speak anecdotally. I was a kid whose parents didn't give me good sex education. Unfortunately, I was able to go to library and read books and learn things that I was not learning in school and was not learning from my parents. And frankly, I've learned a lot in my life from going to the libraries. It is important that those resources be there for young people throughout life. I mean, adults can benefit too, and I think it's much healthier to have them go to a library and read textual material than to look at TikTok videos and graphic, pornography and all that. They're a lot safer at a library. Yes, I can understand there are some issues, some items that parents might not agree with, but then it's up to the parents to accompany them to the library or guide them. But I think, they're going to hear some of this stuff at school, on the school bus, after school, whatever. I think it's naive to suggest that the library is the sole villain in this, and I worry that this legislation casts them in that light.
Yeah, and I think it's erroneous to suggest that the librarians are being made the sole villain in this. And I think that
of this legislation,
we unfortunately we have to be concerned about the welfare of many children in this state because their parents are not going to be.
Agreed.
Okay,
we all agree on
and
that.
So when we have institutions, and that's what this talked about. In fact, Senator Burns mentioned earlier, institutions, right? These are institutions that are being tasked with making sure that children and adults have access to reading material, right? That comes with a responsibility. And so I think it's incumbent upon all of us to do what we can to protect children in this state. And it is our job to make sure that that's happening.
I understand that, and I appreciate that, and I thank you all for your support of Georgia Libraries.
And you have one more question, actually, if you can wait. Representative Pennish.
Thank you. Thank you for being here. You've heard other witnesses say that, and the authors say this is not about criminalizing librarians. But isn't it true? The code is literally the criminal code, Title 16. And the only way a librarian could prove that they are not violating the law is after they are already arrested, is to put up an affirmative defense, citing was not aware of such harmful material, number 2 or number 3. But the damage has been done either by the arrest before they can prove their innocence, which shouldn't be because that's not how this Constitution works. But also they will be chilled into putting everything behind locked doors, giving kids access to really nothing.
Well, that's exactly my concern. How do you prove that you're not aware of something? How do you defend yourself, especially in this day and age? And there is an incentive here. If, let's say, somebody hears make a criticism of a book, it is almost incumbent on the employee then to say, oh, we're going to have trouble with that book. I think it needs to be investigated, and it needs to go before a review committee, or it needs to be removed, or whatever. That process has to be started by a librarian in a defensive posture, because if they don't, they have to do it ahead of the time. They can't do it after the fact. So if they're worried about a problem with a book, they have to finger that book and launch a process as described in sections 2 and 3, and that's not healthy because, to be on the safe side, okay, I'm going to write a memo saying that this needs to be reviewed, this needs to go before a committee, this needs to be reviewed, when in fact I don't really believe that, but I'm just doing that to cover my...
I have one follow-up.
Sure.
Are you aware of any society where banning books has resulted in anything good?
Well, I've only been on this earth a limited time, but I haven't seen any evidence of it. And I'm somebody that grew up with a desire to learn and who liked information. I've always appreciated, libraries for that. And I think we live in a time where it's important to see all viewpoints and be able to get facts, and libraries are very important to that. And I will acknowledge that there may be things that rub some people the wrong way, but again, that's a parental responsibility. Better that those materials should be available for those who can seek it out, or for those for whom it's appropriate, than to just make it not available or restrict its access to adults and young people.
You have a few more questions, so if you can hold on real quick. Chairman Leverett.
I guess in response to Representative Panich, I'm not sure where this bans a book. I don't see a ban of any book in here. Now, admittedly, it does require you to undertake, I think, a greater qualitative review than I think most librarians are comfortable making.
Well, I don't have the text in front of me, but it sets up a procedure where a book is to be reviewed for its appropriateness. You know the language better than me. I'm not saying this is causing the banning of books, but it launches a procedure, and once that procedure has been launched, do all the systems even have a mechanism for dealing with that? That, to me, that's part of the ambiguity that concerns me.
To be fair, you did not say that. My good friend over across the table did, and I don't feel like that's a fair characterization of the bill. But I will acknowledge that it would require you as a librarian to engage in a review and what I call a qualitative assessment of a book that you probably are not comfortable making, because your job as a librarian is to disseminate books and information, not to hold them back.
But I think that underestimates what librarians do, because they have this person-to-person contact with patrons, and I do think that to the best of their ability and with their knowledge of the materials, they try to ensure that the materials are appropriate for whoever's checking them out. They're not just randomly, they're there. They know they're card holders. I see it myself at our library. So it's not willy-nilly. But I'm concerned about these provisions that would require a librarian to have launched a process for the review of a book to protect themselves against a misdemeanor crime prosecution.
Understood.
Thank you.
All right, Chairman Crow has one question.
I apparently have one more question. And it'll be quick. And actually, it's more of a statement than a question, because you keep talking about, them not being aware of harmful material and how do you prove that? I would just say that the burden of proof is on the state to prove they were aware. It is not on the person who has been charged with the crime to prove they were not aware. The burden is on us to prove they were aware. So that's not their burden, it's ours.
And you're absolutely correct with burden of proof.
Where does it say that?
That is the literal, I practice criminal law.
Okay.
I'm telling you, this, you get charged.
Uh-huh.
And then in your trial, you say, or you provide a notice, like insanity would provide a notice. I noticed that I was not aware of such harmful material. Then the burden has shifted to the defendant. That's not the way criminal cases normally go. Normally, the burden is entirely on the state. It's not when you have an affirmative defense. And I'm happy to discuss this later.
Well, but your point about it, the burden of proof being on the prosecution is well taken. But in our society today, we see a lot of prosecutions where there's no substance to it, and you're going to get a zealous prosecutor who wants to make a name for his or herself, or whatever, or a politician. Not anybody in this room, of course, but you're going to get a prosecutor making an allegation, and that's damning enough if you're a librarian to be charged with this, regardless of the outcome, I think.
All right, thank you, Mr. Clinton.
Thank you very much for your time.
Next is Stacy Brown.
Hello. Madam Chairwoman, Committee, thank you so much for your time today. I will be brief because a lot of the arguments and comments have already been made. I am a Georgia resident. I've basically born and raised, lived here my entire life. My mother, 30-year educator. And I have very fond memories of accompanying my mother to the public library where we checked out materials together. And I have a great love for libraries. I've been a librarian for over 20 years now, and I am a director for a mostly rural system in Georgia. I have a lot of trustees. Our board has 68 trustees, which is the largest number of trustees in the state. And we occasionally will receive a book challenge, and there is a process that the board goes through whenever we have a book that is challenged. These board members were all appointed by their counties and their cities to these board positions, so they live in the community. They know the librarians and the library staff, because not everybody who works in our libraries is a mastered librarian. And they're aware of the books that we're purchasing, many of which are for the public that uses our libraries, for local people. They come in, they suggest titles that they want on the shelves, and sometimes those titles are not for everybody. And we completely understand that there's content that's going to be in a library that not everybody will agree upon. What is good for one family is not necessarily going to be appropriate for the other. So I've heard a lot of discussion about protecting children, and we do everything that we possibly can to protect the children and the families that come into our libraries. It includes adults. We want to protect those adults as well, but it's the children that we are most concerned about, and we have policies in place to protect those children that are coming through the door. In my system, they can't be under 12 years old without an accompanying adult. And if a child is in our library, we are going to take the necessary steps to find that adult, whether it's a parent or a caregiver, a guardian. It doesn't matter. They have to have an adult with them. There's filtering on computers.
You can wrap it up, please.
Okay.
Thank you.
So there are processes in place to protect those children that are coming into our libraries.
Thank you. I don't see any questions. Thank you.
Thank you so much.
Next is Kathy Polatsky.
She's not here, but I'm stepping in for her.
Okay.
I'm Emmanuel Mitchell.
All right. Go ahead.
Good afternoon, Madam Chair, committee members, and Senator Barnes. I thank you for allowing me to have this moment to speak before you about the bill that we are having such a courageous discussion about. And I've been a librarian for 24 years. I've been a director of an academic library. I've been a director of a legal library. I was the executive director of the Georgia Department of Corrections Library. I've served as a deputy director out of state, and I'm back here as a director. My career started as a children's librarian, and what I can tell you is we are, for the most part, trained very diligently to make sure that we keep harmful information out of the hands of children. I've heard some questions and I've heard some thoughts and statements prior to me stepping up, and I would consider myself an expert on that. And if you have any questions, I'm here to answer them completely. I can tell you how the library is set up. I can tell you how it's categorized. I can tell you what those books you're so courageously discussing about, where they belong, why they were there, and why were they put there as well. Our library systems in the state of Georgia is one of the best. We are world renowned for having such a great system. And this comes from training, working very diligently to make sure that we serve the community. My philosophy for the library is that it is the center of the community. Everything should ebb and flow through the library, and no matter how small the population is, there should be something there representing them. This bill would definitely destroy libraries as a whole. Not many library staff are professionals, so they're not going to read the whole bill. They're going to come to exemption and think they're going to go to jail. Also, if you arrest a librarian, you've destroyed his career because we are licensed by the state of Georgia. And that's very impactful. Then you have to defend that. Then you have to work to get your license back for something you say you didn't know. But many of you, do you know the classifications of librarians? Do you know that there are catalogers? Did you know there are reference librarians, there are children's librarians, there are adult librarians, there are special collections librarians, there are also archivists? So in a library, it could be a staff member that was asked to go down to children's to grab something and pass it on. They could be a reference librarian, not even have the knowledge of what they were passing on. But what I can assure you is, in my library system, they're not going to pass on anything that's harmful in our children's area.
Thank you so much. I have one question for you.
It's super quick. You mentioned that librarians are licensed by the state.
Yes.
And then you named all of the different categories.
Correct.
Is each of those a different license? Or is it one licensed librarian?
It's one licensed librarian, but they have specialties. Just like a heart surgeon goes to school to be a heart surgeon, a children's librarian goes to school to be a children's librarian. That's their specialty.
Okay, but there's just one license, but then they may specialize in.
Correct.
And I'll use a crude analogy because that's from my background. Thanks, Ron. I currently own a real estate brokerage. And so I have a real estate broker's license, and we have a broker's license and a salesperson's license. But anybody who has that license, they could sell land, they could sell farms, they could sell single-family residential, they could sell multifamily residential, they could sell commercial. But it's one license and one test. Is that the same way?
No. The
Okay.
license is based upon your, you have to submit your grad school transcripts. Your license is based upon your specialty. Basically, when you get your license, everyone is specialized. So if you're a reference librarian, you're specializing in research.
Okay, so your license says reference librarian.
No, it doesn't. It just says it's, I think it's a B5.
And is B5 reference librarian?
No, it's not. It's just librarian.
Okay, so there's one license type.
Right.
Then people specialize under that.
Correct.
Okay, thank you. I was just curious. Thank you.
All right, that's all the questions. Thank you so much.
You're welcome.
Next is Carrie Armistead.
Good
afternoon.
Thank you.
Or good evening almost.
Thank you. My name is Carrie Armistead. I am a librarian. I have a master's degree from the University of Illinois. I am the proud daughter of a public librarian who gave me books like It's Perfectly Normal and Where Did I Come From and What's Happening to My Body, just to name a few examples. I'm sorry, mic's not on. I wear a few hats today. I am the co-chair of the DeKalb County Public Library Board. I am a Doraville City Council member. So I'm here today because I personally oppose this bill, our library system opposes this bill, and the city of Doraville has adopted a resolution formally opposing it as well. Senate Bill 74, as you've said, does not ban books, but it does represent a legislative demand for librarians to do exactly the opposite of what they have been trained to do. Unlike a commercial entity, libraries are public forums with a mandate to provide access to a diversity of ideas. The library exemption exists because the harmful to minors standard is inherently subjective, meaning that what I define as protecting children might be different from what you define. Without that exemption, the threat of prosecution means one person's objection can strip a book from everyone else's reach, violating the very professional ethics that librarians are trained to uphold, which I know you've heard from other people today. I did want to mention that, and I only have this via text, so I apologize, but I had heard that there was an amendment to the amendment under consideration that would replace lines 17 through 23 in this bill with wording as follows. A person who has followed established policies regarding materials reconsideration requests and complied with governing board decisions regarding the material in question. So I interpret that to mean a librarian has exercised their professional judgment to put something in the library collection. That material is challenged for whatever reason. It goes through the proper channels for that challenge. It's decided that that material should be removed or moved to a different section of the library, and only if the librarian then goes against that recommendation, they would be punished. I don't agree with criminal charges for any librarian, but only then would they be sanctioned, basically. So I don't know if I'm allowed to ask you guys questions, but I didn't know if you all had discussed that or if you wanted me to read it again or had any questions.
All right, any questions from members? Sorry, yeah, Chairman Crow.
That part that you read is not currently in this bill, those words that are in there.
Correct.
There's some different language on 17.
Correct. I think this would be a proposed new language.
Is what you're asking, what you were proposing,
okay,
correct.
I'm not
Okay.
proposing, but.
All right, any questions from members? I don't see any. Thank you so much.
Can I text it to you?
Yeah, that's fine.
No,
Okay.
you have to give her your phone.
All right.
All right, that's it. Thank you so
Thank you.
much. All right, next is Alexa Finke.
Hi. Whoops.
Okay, good afternoon, Chairman and Board. Thank you so much for the opportunity to speak today. It was a last-minute thing, because I didn't realize that we were going to be bringing this bill back up, which I'm glad and I'm in support of. I am a citizen advocate, advocating for the innocence of children in Georgia. I've also been an advocate for ending sex trafficking in Georgia, and let me say I've given some talks, and also I've learned a lot about how pornography is the PR arm of the sex trafficking industry. And as you've seen pornography rise through the years, sex trafficking has also increased, so has sexual abuse. And I just want to make a comment. Someone earlier mentioned the gay and lesbian community, about how they may be impacted by this. And I just want to say that gay and lesbian youth are also deserving of our protection in the state of Georgia. Organizations need to quit using the gay and lesbian community as a guise to get porn in schools and books. I love libraries. I'm here for librarians, and I don't feel like that this should fall on their shoulders. And I do know and want to thank y'all for passing the pornography bill. And I know that a judge blocked that bill, but what it did here in Georgia when y'all passed that, Pornhub was worried about being sued in the state of Georgia, so they shut down, which is a win, I say, for ending pornography. I just would like to say that maybe that this bill, if it's passed, maybe that will put the onus back on the distributors and manufacturers of these books, because some of these books are targeted, like this one in particular that y'all looked at. It's manufactured and created for kids at the age of 10. And there are illustrations of people from all ages, both sexes, with their clothes off. And I'm like, how did we get from see Spot run to see Spot without his clothes on? Because that is not what we should be doing to our children. Our children deserve better than that. So I would also like to bring up, I don't know if anybody's brought this up, but the National Center on Sexual Exploitation, NCOSE, they put out a Dirty Dozen list every year. In 2021, they put EBSCO on their Dirty Dozen list. It's a top 12 list that they are entities, the top 12 entities for that year that they feel are sexually exploiting minors. They put EBSCO on there, and you may not realize this or not, but in your kids' schools, they are issued school devices. And EBSCO are on those school-issued devices. And it is like a digital ebook database that has an online portal to books. But also in that portal, they were actually advertising porn sites on that portal, which then students are going to look at books, and then they're seeing advertisements for porn sites. So I do feel bad for the librarians. I don't want them to, for it to fall on their shoulders. I don't know if there's ever anything that we can do also to get them to quit targeting materials that are harmful to minors in the first place, to then put it on the librarians.
Thank you so much. I don't see any questions. Next is Lucia Frazier.
Good evening, Lucia Frazier. Thank you very much for letting me speak. I'm just a simple mom. I would not have known about this except for I know people that dig into this sort of thing. So, that's the first point I want to make, is that there's a lot of people here who know about this stuff because they research this stuff. There's a lot of us who don't know this, and our kids could slip and fall into this situation, and that's not right. It's incumbent on all of us to keep this material away from children. I'm in support of this bill. So I know some people are worried about some unintended consequences, but we can't allow these. It's like leaving a trail of breadcrumbs for children to follow to inappropriate material. It's like Hansel and Gretel. We're not going to do that. I guess my other question is, why would a person even want this material available to children? I did hear some of that today. It was just very disappointing to hear that, that I heard a lot of people speaking, that were against this bill, but then then they were in favor of allowing such materials to young people for various reasons. So it makes me sad to hear the disrespectful agenda hiding behind protecting librarians. So if there's a valid reason, to change something on this bill, let's do that. But
I'm just so sad and disappointed to hear some of the comments today. I would say exposure from any other place is not an excuse to say it's okay. I would say there are many other books to read other than such immoral ones. I don't think the curriculum should even have, anatomy either. I mean, in Kindergarten Cop, I think that scene shouldn't have been in there. There's a level of conservatism that we need to go back towards. I think we're way out of line. I would say it's okay to err on the conservative side when you're deciding where books go. Just put more in the adult section, and then there are still plenty of children's books that are really easy to look at and say, oh, this is okay. I'll put it in the children's area. So just err on the side of putting them all over there in the adult section, and then if things need to be reviewed, maybe something can be brought back. But it is not anyone's decisions but the parents to decide when and where and what these children are going to read. And then the other thing I guess I wanted to say is some of these kids don't have their parents watching them. So yes, then we're doing this. Thank you.
Thank you. Next is Lydia Willoughby.
Hi everybody. Tuck in here. Hi, I am a librarian. I live in Fulton County, but I'm speaking to you today as a survivor of childhood sexual abuse. And I think it's really important. And I also want to say my experience. I grew up in South Carolina. My people are from Georgia. My grandparents lived in Upson County. So I guess I could say I'm like whatever. I don't need to get into family stuff, but I grew up in Irmo, South Carolina, and there was book banning at the time. Teachers were not allowed to say the word gay in any of our classes. There was like a massive walkout protesting overreach by the administration, trying to basically shut down student journalism. But the thing that was most upsetting was like they wouldn't let us read books like The Color Purple or Ruby Fruit Jungle or all these books that, like, as someone who, was surviving things that happened to me or my peers, I thought it was really interesting how, banning obscenity doesn't stop obscene things happening to young people. And also, like, the idea that their innocence can be lost is to discard these children. And this idea of purity is not something that I think is going to be helpful for kids. I think that anyways, my point is that banning obscenity doesn't stop obscene things from happening to kids, but what it does do is stop them from having a language to be able to understand and identify what's been happening. And that only helps groomers. That only helps people that want to hurt children. And I can say this because at my high school, we did. My orchestra teacher was convicted of pedophilia or whatever it is called, but he was my teacher from 5th grade until he was charged. And I don't think that when I did read The Color Purple illicitly, that's when I was able to figure out, like, oh, this is abuse, right? This is actually abuse. And I don't know. I just think that it only helps. Kids need to be able to identify what's happening to them. And some things that they don't understand, they need to have a framework of just like, just because it's sexual doesn't mean it's consensual. And I think that that's a really big part of helping kids understand that through trauma. I also want to say that libraries are one place this kind of stuff could be exposed to, but there's a long tradition in like the Catholic Church. I think it was in 2022, there were over 38 Baptist pastors in Georgia that were had allegations of sexual assault of children. So these things happen outside of other places. And if we want to care about supporting children in libraries, we would fund libraries to have more programming so that we can have more people in the library, more social workers in the library. Thank you.
Thank you so much. Next is Madeline Alzamora. Madeline Alzamora. She may have left us. Janet Wilson. Okay.
Thank you for this opportunity. I guess I just wonder. I wonder why it's so important that these books are in a library. If they can't be, I understand somebody said that's if it's considered pornography, that on the street it would be, though it'd be illegal, but it's okay for the library. The other thing is, as far as the librarians are concerned, I don't know whether they are actually ordering the books. Who's responsible for ordering the books and making those decisions? And then they're held responsible if it's not them. So I don't understand why they're so, I just don't understand why it's so important that they're battling for these books in the library. And then there wouldn't be any, issue here today. But I don't feel that they should be held accountable if they're not ordering the books. I wonder where we can stop the books. So that's all I have to say. Thank you.
All right, thank you. Jill McCoy. Jill McCoy.
I've crossed out so many things on my notes because they've already been said to reduce it down to 3 minutes.
Okay.
My name is Jill McCoy. I've retired out of the Army after 28 years. I am a resident of Evans, Georgia, and have been for 23 years. I am a grandmother of 4, and I care about what's happening in the libraries, and so I'm coming here as a concerned citizen. So, jumping over a bunch of things, bottom line, in the military I always say bottom line up front, I want you to support Senate Bill 74 for many, many reasons. All right, and I'm going to jump over to legal stuff that has already been discussed, but I'm going to talk about why that bill was made and passed in 1984, and that was to protect librarians and school libraries when the beginning of sex education and all these type of programs were starting. Okay, yeah, so legally, down the street, that would be illegal to have that book. So this was back in 1984. Let's fast forward this 42 years, okay? Some of you weren't even born 42 years ago. But there's been an onslaught of books. Anybody and everybody can write a book and want it in the library. And so all the different lifestyles and the stories that go behind them, which may not be appropriate for children, it's like sexually explicit word, pictures, diagrams, stick figures. There was a lady in our library that was upset because her kids were sitting on the floor in the children's section, this happened several years ago, pulling books off the shelf like a lot of kids do. Pull the book up and sit there and look. She was appalled. And that's what started a lot of balls rolling in our community. So we do need to have some guidance for the librarians. I know they're educated. A lot of them, they're licensed. I'm licensed. I have to follow laws and rules too. So I just want to talk about many things here, but it's time to change this law to protect our most vulnerable population from being mentally and emotionally robbed of their innocence. I heard the story about Dave's granddaughter. That could happen to anyone. And that's one of those situations when you see something like that with an innocent mind that's never seen it before, they can't unsee it. And going through therapy, and that happens with anything. Movies, horror movies, think of yourselves. How old were you when you first saw something that has not escaped your brain even at the age that you're at? I still think of that one movie, horror movie, that I still think about. Anyway, bottom line is, research and clinical observations associate early exposure to these materials with increased anxiety and stress, in me right now, okay, premature sexualization. Whoa. Bottom line is, we need to support this to take care of the children. And the children are our future, and we don't want to create demented future. I don't know. Talk about.
Thank you. Brett Crome. Just
Thank
to let y'all know, we have one more after this, and then we'll have Senator back. Thank you.
Thank you. This is a simple bill. It's basically a cleanup bill. Currently, if an adult shows pornographic material to a child or minor outside of the library, they're committing a crime and going to jail. However, if they simply step into a library, somehow this is deemed acceptable. This bill closes that ridiculous loophole. This bill is not about librarians, it's about libraries. With this bill, simply, we want to protect children. The we is not a vocal minority. I believe all people who are not evil want to protect children from harmful material. If a minor is prevented from seeing a certain harmful book, that is not a ban, that is a benefit. Therefore, we should close this loophole and make sure librarians are as safe a space as any other place, maybe even more so, since libraries are where you find lots of kids. You've heard from the opponents of this bill that say that the bill is trying to penalize librarians. This is a false attack. It is very explicit in this bill that any librarian who does their best, quote, a good faith attempt to remove or prevent harmful content from getting to children, they will have an affirmative successful defense. This bill will just criminalize the criminals in and out of the library equally. And finally, let me go on record that this is a shame that the bill has been watered down. We're going to have to keep fighting and seek more legislation next session due to this watered down language to fully protect children in Georgia. Thank you.
All right, thank you. And our last is Robert. I cannot read your last name on here.
It is fine. Spelling was never my best. So,
if you can introduce yourself and your organization, yeah, thank
absolutely.
you.
Hello, my name is Robert Aycock with the Professional Association of Georgia Educators. I know the hour is late. I'm the last speaker, so I'll try to go as briefly and quickly as possible. We do share some of the previously raised concerns about some of the vague language in the bill and others, but I'd like to also raise another point and say that we would also support the possibly proposed amendment to change the language for kind of a specific reason. A couple of years back, I think 2022, the General Assembly passed SB 226, I believe, which established a process for reviewing and possibly removing harmful materials in schools. And if it is the will of the community, the desire of the community to try to criminalize school librarians or other librarians who do not follow set processes, then I'm not sure this language would perhaps do that. Instead, it opens up another avenue of trying to enforce removal of materials or perhaps criminalize librarians and adds additional workload. Instead, the proposed language could possibly make that a little more clear that this only would affect librarians who willfully disregard such processes, and then further supports the procedures that you guys passed a couple years back.
You have
Happy to answer any questions.
Sure. Representative Penich?
Sure.
So, if you believe that the committee will pass this legislation,
Yes.
notwithstanding your objection,
Yes.
you're asking for this amendment to go in to make it an additional affirmative defense?
Yes. Now, obviously, this language would not, move us into a position of support of the bill. We still have general reservations, but if it is the will of the community to move it forward, we at least ask them to consider changing the language so it only is targeting librarians who do not follow, prior established procedures and doesn't open up a kind of a parallel procedure. Because with SB 226, I can't speak for non-school libraries, but in SB 226, the process to determine if a material is harmful is actually up to the principal, and they're in charge of addressing that. So this is kind of, I won't say it confuses things, but it does kind of open up a kind of a separate process where the librarian would need to go through, try to make all these determinations. Meanwhile, the principal is reacting to complaints brought by parents. So if the committee would like to just further support and affirm its previous actions in previous years, then perhaps that language would be better in doing so.
All right. Any other questions? I think that's it. Thank you so much.
Hope that was quick.
All right, Chairman, I'll have you back. And I'll give you maybe about 2 minutes or so to close it out. Thank you.
Thank you, Madam Chairman, and thank you, committee. I appreciate your patience and your attention and your interest in this issue. I want to thank those who've testified, both those who support and those who oppose the legislation. I recognize it's a sensitive issue. I recognize that not everyone might agree with the approach that we've taken in working to protect children from harmful material. I want to reiterate, bad word, I want to focus on the reality that this is not an intent to penalize anyone, not to penalize a librarian or any staff member in a library. It is designed to ensure that material is appropriately cataloged and appropriately placed, and that the parent has the ultimate decision about what their child may or may not be exposed to. So, I ask that you accept the committee substitute that I've worked hard with Chairman Smith, and allow us to move on to the next step so that we can protect Georgia children, but at the same time ensure that our librarians are not unduly burdened. So thank you to the committee. I'm happy to respond to questions.
Thank you, Chairman. We have Representative Penich.
Thank you, Senator.
Thank you.
Senator, I know you're saying the intent is not to criminalize it, but you recognize that this is in the criminal section of the code.
That is correct.
Representative, can you put the mic up?
Sorry.
That is correct. It's in the criminal section of the code because that's where these statutes reside. Recognize that a sixth grade school teacher does not enjoy an exemption. You recognize that a convenience store clerk is not afforded the exemption. They must comply with the law as it stands, which means it is a criminal offense if you provide harmful, obscene material to a minor. Now, I appreciate the challenge that the librarians face in their requirement to understand a large volume of information, but at the end of the day, they should be able to evaluate material and appropriately catalog it. I will focus again, there's nothing in the legislation that eliminates any material from a library. It simply says place it in an appropriate section for age-appropriate material.
Are you open to the amendment that was presented?
I have not seen the amendment. I would suggest that my conversations with Chairman Smith, he is comfortable with the version that you have in front of you, and I would ask that you consider the version that Chairman Smith and I and others have vetted.
All right, Chairman Leverett.
Mr. Chairman, my understanding, and Madam Chairman, this is maybe a question for you too. The version of the bill before us is LC 481607S.
That's correct.
Yes.
I would just note in Section 2, it has an effective date of July 1, 2025.
I did notice
Yes.
that. I think we'll get that fixed.
And unless we're going to also talk about time travel today, I think
That's right. Thank you for that. That's Scribner's era.
That is. We'll get that fixed.
That may be an easier
amendment.
resolve than
All right, Representative Byrd.
Mr. Chairman, thank you for bringing this bill forward. Who actually purchased the books for libraries?
That is a question that's beyond the scope of this legislation. So candidly, I could only speculate, or I could ask the professionals to provide that information. I would suggest that the materials are purchased on a process that when I was in university environment and I had libraries under my responsibility, generally speaking, book lists come out from publishers and they're presented to the librarians as this is the current available top tier material, and oftentimes the librarians accept that recommendation without a great deal of scrutiny. Now, having said that, that was my experience at the university level. I would not suggest that that's also true at a public library or even in a secondary school system. But I have the sense that some material is making its way into our libraries through associations or recommendation arms or buying type orientation that says, I have X amount of dollars to spend for new material, and these are the recommended materials that we can provide you.
Thank you.
All right, any other questions from members? All right, that is all the questions, and I'll entertain any. All right, we have to do a motion first. If that's going to be, I will entertain any motion to pass first.
I'll make the motion.
All right, we have a motion to pass. Do we have a second? All right. Do you have a question?
No,
Okay,
sorry.
it's okay. All right, so we have a move to pass and a second. Representative Penich, do you have a motion?
I do.
All right, your mic's on.
Amend the bill to replace line 17 to 23 with has followed established policies regarding materials, reconsideration requests, and complied with governing board decisions regarding the material in question.
Do you have that in writing somewhere,
I
just
can
on your
just give it to
phone?
Can we
Okay.
get a copy of it, Madam Chair?
Yeah, if we can,
I can send you a screenshot.
okay. All right, so we have a Penich motion to amend and a second. Chairman Leverett.
I can't write that fast.
Sure, can you just, to make sure that the members all know?
Policies regarding.
Has followed established policies regarding materials, reconsideration requests, and complied with governing board decisions.
Has followed established policies regarding materials, reconsideration requests,
And complied with governing board, there should be a comma, regarding materials, comma, reconsideration requests, comma, and if you like an Oxford comma, as I do, and complied with governing board decisions. And complied with governing board decisions regarding the material in question.
And so that language, you want to strike 17 through 23 and insert that language, is that
Yes.
correct? And
Yes.
that's the Penich amendment.
Could you read that one more time for me, please?
Sure. Has followed established policies regarding
Okay.
materials, comma, reconsideration requests, comma, and complied with governing board decisions regarding the material in question.
Yeah.
And complied with governing board.
Regarding the material in question.
Comply with governing board material.
Governing board
decisions
decisions regarding the material in question. All right, so we have a Penich motion to amend and a second. Any discussion? All right, anybody in favor of Penich amendment, say aye.
Aye.
All right, those opposed, say nay.
Nay.
All right, it fails. So now we are there any other motions? Okay, we have now the motion to pass and,
Madam Chairman, I'm sorry.
Sure.
Have we made the motion to change the effective date?
we have not, go
May I
ahead.
make that motion? I would move that
correct.
on line 25, the date of July 1, 2025 be changed to July 1, 2026.
Thank you.
Okay, do all members have that? Okay. All right, so we have Leverett amendment to line 25 to change 2025 to 2026, and we have a second. Any discussion? All right, all those in favor of the Leverett motion to amend, say aye. Aye. Those opposed, say nay.
Nay.
Okay, it passes. Any other motions? All right, so we have a motion to pass in a second. All in favor of passing SB 74, say aye.
Aye.
Those opposed, say nay.
Nay.
All right, it passes.
Could.
You'll get louder.
You could.
Thank you, Senator.
Thank you.
Thank you,
Thank you, Madam
everyone,
Chairman.
for being here
Thank you for your
and
time.
waiting. And that concludes our business, and we stand adjourned. Thank you.